Is April 1st. I'm hopeful that there'll be no April Fool jokes in this committee today. I would like to first ask us to rise and do the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. I will open the hearing on Senate Bill 486 and recognize Representative Grota to introduce the bill.
Thank you, Madam Chair. I'm Jackie Grota. I represent Rockingham 24, and I'm here to introduce House Bill 486, which is a very similar, if not identical, bill to House Bill 1261, which we heard in this committee earlier this year and passed. So this is a bill that addresses the Administrative Procedure Act, which is part of the Committee on Administrative Rules and the Administrative Rules Department. And the director is here, so I think he'll be able to answer the questions that you might have.
Thank you very much, and thank you for introducing that on the fly. We interim studied the one that was here with the same amendment when we had been considering the same amendment that passed in the Senate. We just thought we might still have some open questions. So with that, I will recognize Douglas Osterhoff to speak. We interim studied it. I'll do that in one moment. The same one, just so we could have this.
Good morning, Douglas Osterhout, Director of the Division of Administrative Rules for the Office of Legislative Services. Representative Grota is correct. So this is a parity bill for House Bill 1261, the one we interim study. The language in the Senate bill is exactly the same. The only difference is that the amendment we asked for, or I asked for on the floor here, is incorporated into SB 486 now. But other than that, the language is exactly the same. So my prior testimony is going to be the same.
Okay. Thank you very much. I appreciate that. I know that we had been looking to see if we needed to do some clarification around the legislative intent. We don't have any progress on that yet, but we will either have progress or move forward with this bill as it came out of the Senate before the deadline is up. Are there any questions for Mr. Osterhout? Seeing none, thank you. And is there anybody else to speak on this bill? Seeing none, I will end the hearing on Senate Bill 486, and we will be back in 5 minutes for Senate Bill 527. With this, I will open the hearing on Senate Bill 527, and I thank Representative Moffett for being willing to introduce the bill for Senator Lang. I know that the scheduling is challenging trying to get between two buildings where the commute time's a lot longer than the walk through the tunnel.
Thank you, Madam Chair. Great to be here in ED&A. For the record, my name is Representative Mike Moffett. I represent Merrimack 4, which is Canterbury and Loudon. And yes, SB 527 is from Senator Lang, and I'm happy to introduce it. I'm not a co-sponsor, but I will tell you that Philip Trowbridge is here. He's sitting behind me to my left, and I would recommend or ask that you defer questions on this to this gentleman who clearly is more knowledgeable than I am on this at this time.
Thank you very much.
Thank you, ma'am.
Thank you. I'll call Philip Trowbridge up to speak on the bill.
Good morning.
Good morning.
Good morning, Chairman Leyen and members of the committee. For the record, my name is Philip Trowbridge. I'm the manager of land resources at New Hampshire DES. The land resources program does a lot of permitting. Across all our different programs, we issue 10,000 permits a year. And one of the reasons we're here today is because this bill will help us with some modernization efforts to speed up that permitting. So we have a letter of testimony that we've emailed, and I'm also passing around that describes our position. But the genesis of this bill is that, as I said, we do 10,000 permits a year. One of our strategic objectives is to move to online paperless permitting. And when you do something like that, you go through a lean process with your programs to see how you can make it more efficient. And through that, we discovered that one of the steps that was a barrier for us was actually in that was in the Administrative Procedures Act that required notification from the department, and any department, if there's a permit from the applied for the state to municipalities by first-class mail, which, as you can imagine, is a barrier if you're trying to move to online permitting. So what we're proposing, and we worked with Senator Lang on this legislation, is some flexibility in that to allow us to use electronic notification in lieu of first-class mail, and also to give us some flexibility about when the notification happens. So the bill's been crafted to give us that flexibility, and we've also worked with the New Hampshire Municipal Association regarding and options for municipalities who don't want to receive electronic communication to opt out. So it's a very flexible bill. It just gives us options. For a state agency who wants to use this, they can. If they don't want to use it, they don't have to. If a municipality doesn't want to use it, then they can opt out. But for the most part, we've been a lot of communication with the towns, and I think it's going to be widely adopted. Happy to answer any questions you have.
Thank you. Representative Slotchie?
Thank you, Madam Chair, and thanks for taking my question. This all sounds pretty straightforward. The only issue that I can imagine is that courts tend to require some sort of receipt of notification, first-class mail being the example you gave.
Right.
Is there any concern from your department that municipalities might claim in court that they never received an email, and having some litigation fall out of that?
We did just thank you for the question. It's an excellent one, and it's something we did discuss. We feel like the standard has changed in that the receipt of information through electronic means is more accepted now. And in these cases, these are just notifications of an application received for an appeal or something that might go to a court. That would all be done through first-class mail, and they'd probably meet that same standard.
Thank you. Do you have a follow-up? No. Thank you. You cited 10,000 permits a year.
Yeah.
So this sounds to me that with full adoption, it'd be saving $100,000 or so. Are there other projects that are already going through that will probably benefit from some of those funds? Or is this something where it's just going to be a good cost-saving measure that can be passed all the way through?
Thank you for the question. I'm not sure I quite understand. I mean, I think we expect to gain efficiencies here, for sure. We haven't estimated an exact amount. And for us, that we've been, there's also some costs associated with the licensing of the software. So, we'll have to see how this all shakes out.
Okay, thank you. That's definitely helpful. And the other question would be if before we move into the budget process, you'd have an idea of how many municipalities are participating and how many still require the first class mail. If that's information you'd be able to make available in the next biennium.
Yeah, we should be able to do that. We were working on a list of communities that have have an email address for their receipt, and most do. And there's only been a few who have opted out.
Okay, thank you. Are there any other questions from the committee? Seeing none, thank you very much.
Thank you for your attention.
Is there anybody else here to speak on Senate Bill 527? Seeing none, I will close the hearing. Did you want to? Sure. And I will open an executive session on Senate Bill 527. Representative Slotchi, do you have a motion?
Yeah, I would like to motion ought to pass. Thank you.
Thank you. Is there a second?
I'll second.
Thank you. Would you like to speak to your motion?
Yes, thank you. I think this represents a pretty straightforward enhancement to the efficiency of delivery of notifications, and seeing no good reason to stand in the way of it, I think we ought to pass it. Thank you.
Thank you. Would you like to speak to your second?
Yes, thank you. New Hampshire agencies have is not something that's common where agencies sort of keep up with the times in New Hampshire. So I'm really glad to see this kind of bill in process, and I thank you for thinking about it.
Thank you. Is there any further discussion on this bill? Seeing none, when the clerk is ready, he can call the roll on ought to pass on Senate Bill 527.
As stated by the chair, Representative Slotchi.
Yes.
The clerk votes yes. Representative Pearson.
Yes.
Representative Bailey.
Aye.
Representative Sellers.
Yes.
Representative DeRoy.
Yes.
Representative Kelly.
Yes.
Representative Grote.
Yes.
Representative Schmidt.
Yes.
Representative Davis.
Yes.
Representative Dargy.
Yes.
Representative Howard.
Yes.
Representative DeVries.
Yes.
Representative Chair.
Yes.
Looks like 14-0.
The motion passes 14-0. Is there any objection to the consent calendar?
No.
14, we're down Thebo and Long. Oh, he's not here. Yes, he's over in the Senate introducing his bill. Yes. Thank you. Is there any objection to consent? Seeing none, this will go on the consent calendar. The executive session on Senate Bill 527 is closed. I believe I have one more that we can do as well. I'd like to open the executive session on Senate Bill 571. That is the bill that was passed in a different form by the Senate and is off to enrollment. And I would like to motion an expedient to legislate on Senate Bill 571.
I'll second.
571. Yes. So this bill is one where we had two similar bills, one in the House, one in the Senate. The House version was amended in a way that was acceptable to both the Senate and those who had sponsored the bill. Because of that, it makes more sense to keep one bill moving forward that has all of the information that is necessary as opposed to trying to add a second one. And therefore, I believe that this bill should be found inexpedient to legislate. We had just held action on it to make sure it wasn't removed from the consent calendar last week. Would you like to speak to your second?
I believe the chair has completely covered the subject. Thank you.
Thank you. When ready, the clerk can call the roll.
On inexpedient to legislate on SB 571, Representative Slotchi.
Yes.
Clerk votes yes. Representative Pearson.
Yes.
Representative Bailey.
Aye.
Representative Sellers.
Yes.
Representative DeRoy.
Yes.
Representative Kelly.
Yes.
Representative Grote.
Yes.
Representative Schmidt.
Yes.
Representative Davis.
Yes.
Representative Dargy.
Yes.
Representative Howard.
Yes.
Representative DeVries.
Yes.
And the chair?
Yes.
14-0.
Is there any objection to this consent calendar? Seeing none, this will go on the consent calendar and the executive session is closed. Oops. And I think we will go ahead and pause until our next hearing starts in 8 minutes. Thank you. on Senate Bill 502 and welcome up Representative Moffett to introduce the bill.
Hello again, Madam Chair and company. Again, for the record, I am Representative Mike Moffett, Merrimack District 4, Canterbury and Loudoun. I am a co-sponsor of SB 502 FN, and I did email the whole committee some points on this measure that should be in your inboxes. So I will say that there are two separate pieces to SB 502 because we use the entire bill as a housekeeping measure to clean up language for both the BEA and the Department of Labor. The Honorable Jeannie Forrester is here in the House. I just spoke with her, and she's here along with Mark LaLiberty for the BEA. And Ken Merrifield is here in the House as well. I spoke to him earlier. He obviously represents the Department of Labor to answer any follow-up questions the committee may have. So I would, I will defer to them because they are the duty experts on this measure and the language that's there we're trying to improve here. So I'll defer from questions and I will let you call them up at your leisure.
Thank you very much.
Thank you, ma'am.
I will call Commissioner Ken Merrifield up, and he's the only pink card that I have, so I would welcome those from the rest of you if you're looking to testify.
Good morning, Madam Chair, members of the committee. For the record, I am Ken Merrifield. I'm Commissioner at the Department of Labor. And I would agree with the comments of Representative Moffett that we view this bill and the subsequent amendment in the Senate as largely perfunctory and housekeeping. I would say the most consequential thing that the Labor Department is asking for in this instance is relaxation of quorum requirements for the New Hampshire Healthcare Workplace Safety Commission. The commission has been very busy in its first 2 years of existence and meeting quite frequently. But we do find, I think we've calculated a quorum at 17 members, and because people are coming from every hospital in the state, we sometimes find it difficult to get to 17 members present in person. So if we could count people's remote attendance as part of the quorum, would help us to make that quorum substantially each time we meet. But that, I think, is the most consequential thing that we're asking for with this legislation, and would be happy to entertain questions.
Thank you. Representative Sitek?
Thank you, Commissioner Merrifield. You said relaxation of what exactly?
Quorum requirements?
Or, thank you.
Because absent other legislative direction, we need 50% plus one in order to conduct business, and we are very close to that almost every time we meet.
Thank you. Representative Schmidt?
Thank you, Madam Chair. So, Representative, you were asking me earlier today, didn't we do this last session or last year, this quorum requirement from this very entity? Because it certainly rings a bell with me that they were exactly the thing. It's a very large entity, and the quorum requirement is very difficult since you are coming from all over the state, and it's burdensome as well. Not only the legal aspect, but it's burdensome to have all these people come. Lord knows it's the same situation with the legislature, but we have hundreds of people involved, so we are able to get a quorum. I don't think I've ever been there when we haven't had a quorum in 24 years. So am I flawed in my recollection that we had this very issue before this committee?
Representative Grota?
Yes, thank you, Representative Smith. We did have something similar to this, but it was a renaming of a commission, and it was a commission under HHS, and it also involved doctors and nurses, and if I'm not mistaken, people from community health centers. It was a similar issue, but it was a completely different commission. But I do remember this. Yeah. You're correct. Yeah.
Thank you. I have a question for you, Commissioner. In Section 17 of the bill, Safety and Health of Employees Generally, Elevator Law, it would add the provisions of 157A, which is the boiler statute, which would apply to all workplaces with more than one employee. To me, that seems like that could be a pretty substantive change that just shows up in just two lines of a bill. And so I'd like to better understand the purpose behind that.
Sure. The Labor Department believes that we have this jurisdiction already. In fact, have practiced this authority for decades and decades. I don't even know how long we've been practicing this jurisdiction. So we think that other provisions of law, for example, 281:64 gives us jurisdiction over that. I think there are other provisions of law. Wish now that I had brought my attorneys with me, but we believe that we have this jurisdiction already. But we had noticed in some circumstance in the last year that in this particular statute, 277, that the elevator authority was spelled out specifically and not the boiler and air tank provision. So we thought that in order to have completely consistent recommendations throughout the statute, that we should include it here as well. So we truly do see it just as a housekeeping.
Okay,
question.
thank you. It would be helpful to get more information from the attorneys.
Yep.
I just want to make sure that we're not acting in the realm that is usually covered by another policy committee if
Sure.
this is a policy choice.
Sure.
So more information would be helpful.
And again, I would say that we have exercised regulatory jurisdiction like this for decades. So,
Okay.
yeah.
Thank you. Are there other questions from the committee? Seeing none, thank you very much.
Okay, thank you.
Next, I'll call up Mark LaLiberty from BEA. If you push the button again, red means go.
Okay.
Thank you.
Hi, Mark Liberty from Candia. I am a business recruiter for the Business and Economic Affairs. I am here in representing in support of SB 502. We worked with Senator Pearl on this cleanup bill. The reason primarily was in 2021, Office of Strategic Initiatives was brought into BEA as Office of Planning and Development as an office. In 2025, it was upgraded to a division of Planning and Community Development. So within that time, there were some RSAs that were looked at. We wanted to clean up a little bit, adjust some committees that were originally OPD that would either want to be at the division level or the department level. And then we looked at a few other things, such as with the establishment of the Department of Energy. We were part of their establishment on helping them out. We are no longer need to do that. They're on their own, so we're pulling out of that. When OPD came to us, we had 2 seats on the CDFA Block Grant Program Advisory Committee. We thought it'd be best to only have 1, and we worked with CDFA on that. They were fine with that. And then the final big thing in here was that BEA was part of the New Hampshire Innovation Research Center at UNH. They discontinued that in 2021, and they are not funding anything. They haven't funded anything in 5 years, so we are being removed from that. We still have a very good relationship with UNH and many of their programs. So I'm here to answer any questions anyone may have.
Thank you. Questions from the committee? Seeing none, thank you very much.
Thank you for having me.
Is there anybody else here to speak on this bill? Seeing none, I will close the hearing. I don't think we're ready to take action on this one yet. I would like to open an executive session on Senate Bill 423. This is the PTSD Commission. I would just want to offer an amendment and pass that out so everybody can take a look at it. So I'm opening the executive session on Senate Bill 423, and I'm I'm moving amendment 1310H to the bill. Is
I'll
there a second?
second.
Seconded by Representative Grota. When we had discussed this bill, which is reinstating the PTSD Commission, we discussed the importance of having the county sheriffs on there as well. And so this would replace the community health centers with the New Hampshire Sheriff's Association. And since this had been discussed in committee, is discussed amongst us and asked of the sponsors and those involved in the bill, and they seem generally amenable to it, I submitted this amendment so that we can discuss it. Representative Grota, would you like to speak?
Yes, thank you, Madam Chair. There was a request by the Sheriff's Association to be included in this bill, and the sponsor said that it was fine with them as long as we didn't increase the size of the commission. I mean, yeah. So this just replaces one group with someone who is actually a first responder group. So I hope that you'll support the amendment.
Thank you. Is there any further discussion on the amendment? Representative Pearson?
Thank you, Madam Chair. I served 2 terms as the vice chair of this commission. It's a very active commission. They've never had a quorum problem. It's usually almost fully attended. This is a logical amendment in the sense that the sheriff's department does different work than the corrections officers. It does different work than normal police officers, and it's fun. It's actually funny. One of the things that they say, and it's a little cliche, but they say in the course of a day, a regular police officer might encounter a criminal, an actual criminal, once in the course of a shift, but folks in the sheriff's department, because of their responsibilities in New Hampshire, encounter them continuously. So this move here just is long overdue, if you will. So I fully support the amendment, and I encourage its passage.
Thank you very much, and thank you for that insight from your participation. Is there any further discussion on this amendment? Seeing none, I'll have the clerk call the roll.
On the adoption, motion is to adopt amendment 1310H on SB 423. Representative Slotchie.
Yes.
The clerk votes yes. Representative Pearson.
Yes.
Representative Bailey.
Aye.
Representative Sellers.
Yes.
Representative DeRoy.
Yes.
Representative Kelly.
Yes.
Representative Grota.
Yes.
Representative Schmidt.
Yes.
Representative Davis.
Yes.
Representative Dargy.
Yes.
Representative Howard.
Yes.
Representative DeVries.
Yes.
Representative Chair.
Yes.
The vote is 14-0.
The amendment
Wonderful.
passes 14-0. I'm not sure if everybody had a chance to look through the entire bill. Is there anybody who wants a little bit more time looking on this before we vote on the entire bill as a whole? Or is everybody comfortable moving forward with it at this point? 423, yes.
That was Leon and Grota, right?
Yes, Leon and Grota on the amendment. And if there's nobody, if nobody is looking to spend some more time looking at this, I would move ought to pass on Senate Bill 423 with amendment 1310H.
And I'll second.
Thank you. I actually think that, Representative Pearson, would you actually like to make that motion, given your history on this bill?
Yeah, okay. If you want,
Okay.
if you
I'll
want.
I'll withdraw my motion if you'd like to make that one.
Sure, I'd be happy to do that.
Of course, that means you have to write the committee report.
I'm well aware of what has been thrust upon me with this motion.
Thank you. Actually, would you like to speak to that, Representative Pearson? I think that you have probably the most knowledge on this topic of this group.
I mean, we've already covered the amendment. So, there's, for those of us that have been here multiple terms, this legislature became kind of drowning in commissions and committees, and we even formed a committee to look at committees, believe it or not. So, but in this particular case, this committee does take action. They produce reports that lead to legislation. Nothing is pencil whipped. There's nothing that's just filed for the sake of being filed. And there have been substantial changes that have occurred within workers' comp law and municipal law in reference to this field. this emerging field of medical study. So, you know, this is just not a simple case of renewing another commission for the sake of renewing it. This organization or this group of folks really has done some substantial and meaningful work here. So this is kind of a no-brainer to me. I don't know why. The only thing I would add is that I find it a little strange that we seem to come back every 2 years and re-up this commission, where perhaps maybe doing this in a longer duration may seem a little bit more logical moving forward in the future. And they can continue to issue reports however the legislature sees fit, but it's perhaps in the future we'll look at making this a little bit of a longer duration in action. So other than that, let's do it.
Thank you. Would you like to speak to your second, Representative Groda?
Thank you. I think Representative Pearson has done an excellent job summarizing.
Thank you. And I would note that Representative Pearson's idea of extending this as an indefinite commission, perhaps if we look at that next year, maybe we can pull back on some of the ones who are currently indefinite commissions to set those on a more of a renewal basis. So I think that would be a larger look than what we're looking at here to just continue the good work. So is there any further discussion? Seeing none, when ready, the clerk can call the roll.
The motion is sought to pass as amended, with amendment on SB 423. Representative Slotchie.
Yes.
Clerk votes yes. Representative Pearson.
Yes.
Representative Bailey.
Aye.
Representative Sellers.
Yes.
Representative DeRoy.
Yes.
Representative Kelly.
Yes.
Representative Groda.
Yes.
Representative Schmidt.
Yes.
Representative Davis.
Yes.
Representative Dargy.
Yes.
Representative Howard.
Yes.
Representative DeVries.
Yes.
And the chair.
Yes.
For the same 14-0.
14-0. Is there any objection to this going on the consent calendar? Seeing none, this will go on the consent calendar. I do want to note that this committee received the most Senate bills of any committee at 35. With the 3 that we have exec now, that means that 18 of them have already come out of our committee. So if we can make sure that we get our reports in, then those can go to the floor next week. And so in the interest of giving us a few minutes to write some reports if we can, I will recess us until we begin again at 11. Thank you. Yes. It is now 11 o'clock, and that means that it's time for the hearing on Senate Bill 488. And I would like to recognize Grant Bossy to introduce the bill on behalf of Senate President Carson.
Thank you, Madam Chair, members of the committee. My name is Grant Bossy. I am the Deputy Chief of Staff of the New Hampshire Senate, here to introduce Senate Bill 488 on behalf of Senate President Sharon Carson, the bill's prime sponsor. If you think back about 9 months ago, we were right at the end of a very difficult budget negotiation, and there was a very real possibility that the legislature and the governor might not be able to pass either a budget or even a continuing resolution before the state's budget authority ran out on June 30th. Unlike the federal government, we do not have a definition of essential government services or essential employees that would be authorized to operate beyond the June 30th deadline that is set in the law during each budget cycle. We prepared for that contingency to ensure that vital state government operations would continue, and found that there was just no legal authority for essential services to continue, nor even for a definition. That left us facing the prospect of closing down all parts of state government, state police, the veterans home and state hospitals, the state prisons, even closing Hampton Beach on the 4th of July. We have not given state agencies the authority to operate for even a day absent a budget or a continuing resolution. Senator Carson has drafted Senate Bill 488 as a way to keep the essential functions of state government running should such a budget impasse happen in the future. Senate Bill 488 would empower the governor to declare a 60-day emergency to keep the essential functions of state government authorized and funded at the same level of the prior fiscal year. It would basically be a 100% continuing resolution for 60 days. The legislature could then extend that for an additional 60 days up to 3 times with a majority vote of both the House and the Senate. This reflects the current balance of budgeting authority between both the legislature and the executive branch. Senator Carson believes we should provide assurance to the people of New Hampshire that even when our government cannot reach agreement on the state budget, the courts will stay open, roads will stay safe, and our hospitals, nursing homes, and prisons will keep operating. I want to thank you for your consideration of Senate Bill 488.
Thank you very much, Representative Schmidt, and then Representative Slotchie.
Thank you, Madam Chair. So I agree with the basic premise entirely, but doesn't the governor have such authority in his capacity to handle and deal with emergencies, to declare that this could happen? Because I remember when it nearly got us last year that we were facing that possibility that everything was going to have to shut down. But doesn't the governor have the inherent authority as governor to declare that the agencies and essential agencies, in any case, will continue to operate?
No, there's absolutely nothing in law, and the governor cannot spend a dollar without the legislature's okay. And the legislature has not given the governor any such authority.
Thank you very much for that answer.
Thank you, Representative Slotchie.
Thank you, Madam Chair, and thank you for taking my question. Does this legislation address, or is the Senate President concerned that the governor might just veto a budget that they don't like and declare a state of emergency and create some sort of feedback loop where it might grant the governor additional power that they don't already have in terms of negotiating a budget?
If you were, as in terms of who would trigger this, there's several ways you could trigger it. You could have the governor do the initial declaration. You could have the legislature do the initial declaration. You could have it just be automatic, and that there be essentially status quo authority in the absence of a budget or a continuing resolution. Senator Carson thought that since the legislature and the governor both have a role in approving a budget or a continuing resolution, that they should both have a role in declaring an emergency in the absence of a budget or continuing resolution. This is how she set the balance. If you think there's a better way to do that, that's certainly your prerogative as the House.
Do you have a follow-up?
I think it underscores an additional concern that I'm hoping you can address around our sort of abdication of authority. So to your earlier answer to Representative Schmidt, the legislature controls the purse completely. This would put a lot of that power back into the hands of the executive. Is there a portion of the bill in your eyes or in your view that, alleviates that concern, or do you view that as a legitimate concern?
It's a policy concern. It's a policy question, and you're the policy makers, so you get to decide how this process would go into effect. Senator Carson thought that an initial 60-day period for the governor and then the extensions being up to the legislature would strike a similar balance to what we have now. Again, that's up to you if you think there's a better way to do it. That would be your prerogative, and the Senate would either, agree with that or talk to you about it in conference.
Thank you. Representative Dargy and then Representative Sellers.
Just let me clarify. Senator Carson does not think that the trigger she have set is the only right answer. So if you do have another answer, she's not going to consider that, hostile to the intent of the bill. If you think there's a better way to structure it, her main concern is that we don't have to open the doors of the state prison at midnight on July 1st.
Thank you.
Thank you, Madam Chair, and thank you for taking my question. I thought I heard you say that this was, in essence, a 100% continuing resolution, but there's several carve-outs that are in the bill. Can you talk about whatever carve-outs there are, or what things that aren't addressed in the bill?
There are several agencies that are not included. I don't think, for instance, the State Department of Education is included. And there was some question about that in committee. The state DOE doesn't have a lot of essential services in July and August. I think there's a lot of interest in getting them running by September, when the first adequacy payments would be going out. So you can decide whether or not adequacy payments or other education aid payments should be added to the list. I mean, I wouldn't want to go through the full list line by line. You'd have to make a policy determination. Okay, yes, this is essential. Maybe no, that isn't essential. And again, if you were to come up with a different list than Senator Carson and the Senate agreed on, that's just part of the normal legislative process.
Thank you. Representative Sellers.
Thank you, Madam Chair. So it's been 250 years. We've never had anything like this, but now we need it. Can you tell me why, besides what happened I thought it was a year and a half, 2.5 years ago, but.
We did have this happen once before. It was in the late 70s. I believe Governor Thompson was in place. We did not have, the legislature and the governor failed to pass a budget. They did not have a continuing resolution in place, and they essentially pretended it didn't happen for the weekend. And they let state government operate, and then they came back in the early days of July and passed a budget. That's as close as we've ever come, and they just kind of faked it for a few days. It was the 70s. It was a looser time. And in the past 25 years since the turn of the century, we have had 3 instances where we have not been able to pass a budget, where we did have a continuing resolution in place. 2003, we had a 3-month continuing resolution. I've got these written down for you if you want them. A 3-month continuing resolution that was based on the prior year's HB1. 2015, we had a 6-month continuing resolution that was based on the prior year's HB1. And in 2019, we had a 3-month continuing resolution that was actually based on the governor's budget and agency budget submissions, not on anything that had been passed into law. All of these are policy questions. How you base it, CR, how you trigger it, who triggers it, and what you define as essential and non-essential are policy questions. For the Senate has made its decision. Now it's up to the House to make its decision.
Thank you. Representative Thibault?
Yeah, it has happened. We've gotten close to it 3 times in the last 25 years, and not including last year when we came closer than we ever had to not even having a continuing resolution.
Thank you. Representative Thibault?
Thank you, Madam Chair, and thank you for taking my question. So I wanted to emphasize some of Representative Slotchie's points, but also hone in particularly on the extension portion. So between the initial declaration and the 3 extensions, it would be potentially up to 240 days of this somewhat continuing resolution. So could you expand upon that? Because that's over half a year of a 2-year budget. And that's a lot of time for the legislature to not really have a say. So could you explain why the Senate decided on that number a little bit?
Senator Carson's preference was to take away some of the brinksmanship that has characterized budget negotiations in the past. To give, if we run up to that June 30th deadline and aren't close, and don't even have a continuing resolution, she felt, again, as a policy preference, that having a little breathing room for the legislature to not necessarily have to come back in the first week in July, to have that initial 60 days to work on it, and then a little more time would be beneficial to ultimately getting to a good project. The June 30th deadline, it's not in the Constitution, it's in the law. We have set that drop dead date for the end of budget authority in every budget that we've passed. This would reset that and say we've got a little bit of breathing room after June 30th should the legislature and the governor fail to either pass a budget or the legislature fails to override a veto on a budget. That's she just thought that giving the legislature and the governor a large length of time might diffuse the situation and lead to a budget resolution.
Thank you. Representative Pearson, and then DeVries, and then Bailey.
Thank you, Madam Chair. Looking this over, looking the very beginning of this, I don't agree with the idea that we're somehow surrendering all of this to the governor. This is the procedures outlined here were the 60 days, and then it has to go to a majority vote in each house to continue. So that I don't see any risk of that. Well, here's where I see the risk, and you joked about it, but I think we need to clarify something. As of right now, if we do not pass anything at all, the doors to the state prison are literally opened. Is that correct?
That was our interpretation of the law. We see no authority to operate any branch of state government after midnight on July 1st.
Thank you.
Thank you, Madam Chair. Thank you for taking my question. You mentioned specifically in your opening remarks about Hampton Beach, and because I live in Hampton, I agree that it would constitute an emergency to close the beach, as we did during COVID. But I don't see, but I could be missing it here in this bill, where it talks about parks departments and things like that, that would be allowed. Or did I mishear you and you actually said that actually would shut down? That is not authorized.
I believe the list the Senate ended with does not, I don't have the bill in front of me. I don't think parks are on the list. You could make a decision that yes, parks, some would consider keeping the liquor stores open for the tourists on July 4th in emergency. That's up to you to decide whether that is an essential function of state government, given the money that we generate, or whether those would close absent authority.
Thank you.
Representative Bailey.
I don't have it in front of me, but we did, after COVID, pass a thing about governor's emergency powers. And I don't think in what was passed there was as many extensions or the periods were as long as specified in this. So there already has been a policy decision about the governor's emergency powers, and relatively recent. And I don't think this aligns with it. I could be wrong, but
What we did, I actually worked closely on that bill just after COVID. What we did was codify a lot of the things that the governor did by emergency order, and we decided these probably pretty good. We should keep doing them. And we also clarified some of the going back and forth during a state of emergency. But we saw no authority for the governor to declare an emergency and therefore spend money and keep operating the state police.
Follow up.
at that time, the emergencies was COVID, but they also came into the debate about policy up to and including Seabrook just melting into the center of the earth. And I don't think a policy dispute is over a budget is of the level that we're talking about with that. It's like maybe the brinksmanship is what gives us the budget. But anyway, I do feel it's a failure to create a budget is short of Seabrook melting into the center of the earth.
I would agree.
Representative Dargy.
Thank you, Madam Chair, and thank you for taking my question. Excuse me. When you were developing this, was there any thought to simply redoing HB1 in totality. It's like Hampton Beach would be open, as opposed to just trying to find things that are critical. There's less important areas of the state government that are important to a lot of people. This isn't like COVID where we were trying to keep people from interacting, and so it was emergency orders to allow various functions to stay open for interaction, where there was an interest in that, in not having that. So why did you choose particular sections and not others, as opposed to just saying, let's keep everything going forward?
That was a policy preference of Senator Carson in drafting the bill and in the Senate in passing the bill, that these are the most crucial to stay open. Another approach could be simply you authorize the government at, say, 3 months at 25% of the prior year authorization, or 6 months at 50% of the prior year authorization. That would essentially be a statewide continuing resolution. That's a different policy approach. Senator Carson thought it would be more appropriate to concentrate on the most critical areas of state government rather than simply letting all of state government continue for 60 days, 90 days, 6 months.
Thank you. I have a question for you based on that response. Is there a mechanism if we were to extend 25% of the budget for 30 or 60 days to then permit the governor to allocate what they viewed as most essential to direct those limited resources specifically to those areas?
Well, that would be if you did it at a lower level. I'm saying at 50% for 6 months, meaning half of their annual appropriation to be spent over 6 months. So essentially level funding. You could also do it as a percentage. We haven't done that in the past, but there was talk this year, last year, of passing a continuing resolution at 90% of the prior year authorization and force all agencies to do a belt tightening as they were going forward. You could. You would likely want to put some guardrails in place, for instance, bringing that back through fiscal or through governor and council, but rather than just letting the governor move all the money around. I would think that the legislature would be interested in getting another look at that as the money gets reallocated, but you could essentially say, we will authorize a set percentage for a set period of time, and the governor has to come to fiscal and tell us how, and currently she, possibly in the future he, would allocate those, and fiscal then has to sign off on it. There are many ways you could structure this. Senator Carson landed on this and thought it would be the cleanest way to do it. But if you wanted to have a different structure that said essentially agencies have to, state government as a whole has to operate on 90% of what they had last year, and it's up to the governor to decide, you could do that.
Thank you. And looking at House Bill 115, which was passed by both bodies, it was a continuing resolution that allowed it to continue at a lower rate. Did you view that as one where it was still siloed within each of those budgeted lines, or is that one that you would view that the governor had flexibility to move around as necessary?
I'm going from memory. I believe it was within each budget line was essentially 90%, and then there is transfer authority, but you'd have to go to fiscal to get that. So if you said, well, this particular part of state government, this program needs 110% of what they got, we're going to take it from this other program that isn't as essential, we'll go to fiscal and get authority for that. But the idea was to essentially, the idea in 488 as passed by the Senate was to say, here are the things we know have to keep operating. We're just going to operate them at the status quo 100%. We think that's the most neutral way that doesn't bias the future budget decisions of a future legislature or a future governor.
Thank you. Representative Sytek, did you have a question? No. Representative DeRoy and then Representative Schmidt.
Not that we're like any other state, but what are other states doing in terms of their?
I do not know what the authority is in other states. We haven't looked at that.
No.
We could ask Senate research or House research to look at that.
All right, thank you.
Representative Dargy.
Thank you, Madam Chair. Would it be possible to get a list of all the functions that are not funded with this bill? What would be shut down? Because what's funded is here, but what's not funded is not clear to me at all. You know, what do we lose with this bill?
Let me write that down, see if we can find out what isn't included.
Correct.
Are there any other questions from, oh, sorry, Representative Schmidt? Although, let's wait for Mr. Bossi to finish
No,
writing.
I wrote
Okay,
down.
now he's
Go
done
ahead.
writing.
Well, this is kind of a big deal, and we're distinguished by an absence of just about everybody that might otherwise be concerned. Was this same lack of public input or concern evident in the Senate hearing?
I don't think there were a lot of people there. I introduced the bill for Senator Carson in Senate EDNA as well, and there was not there were not lines out the door. But I think hypothetical budgets in future years don't necessarily engage the public the way they might members of the EDNA committee.
Follow up.
Follow up.
Thank you. Has the Supreme Court has it been considered to seek an opinion of the Supreme Court with regard to the situation?
That hasn't been considered. We believe that the legislature has the authority with the assent of the executive to set how we budget and authorize spending in the state of New Hampshire. We don't think there's a constitutional question involved.
Okay, thank you.
Are there other questions from the committee? Seeing none, thank you very much.
Thank you.
Next, I'll call Representative Tularski. Thank you very much.
Good morning. Thank you, Madam Chair, members of the committee. A few months ago, I was here.
Introduce yourself. I know
I'm
we
sorry.
all know who you
I apologize. Representative Laura Tularski from Hillsborough 11, Ward 8 of Nashua. I was here before the committee a couple months ago. I hope some of you might remember my bill that tackled this very same issue. That bill was House Bill 1500, and it proposed a framework for what happens if the legislature fails to pass a budget. And that plan kept the responsibility of that decision-making where it belongs with the legislature. That bill did not move forward, as you are all aware. And now we have this Senate Bill 488 addressing the same problem, but in a very different way. And in my view, a concerning way. This bill allows the governor to declare that state of emergency if the budget or continuing resolution is not put into place. But in doing so, it does something far more significant than responding to that fiscal gap. It asks this body to voluntarily give up its core constitutional authority. The power of the purse is one of the legislature's most fundamental responsibilities, and SB 488 effectively forfeits that power at the very moment it matters most by handing it to the executive branch. Under this bill, the decisions about spending, operations, and priorities could be made unilaterally by the governor without the same legislative debate, transparency, or accountability. And that is not a temporary workaround. That's a true structural shift in power. Once that authority is given away, I fear it could be difficult to reclaim. And I want to be clear, the underlying problem we have here is real. That's why I filed my bill to try to look at it. But the solution cannot be for the legislature to step aside and allow the executive branch to take over its role. HB 1500, my bill, attempted to create a process rooted in shared responsibility and legislative control, whereas this bill moves in the opposite direction, concentrating the power in the single office in the branch that diminishes the role of the legislature. And I don't believe that's a precedent we should set. At minimum, I think that this bill should be studied or amended to create a committee to do some more of the hard work to figure out where we can merge the solutions, try to find a comprehensive look at what this problem, the problem that exists, which is we just don't have that process in place. But we should fully examine the constitutional implications and ensure that any solution preserves the balance of power as it exists between the branches of government. I just do not believe that this bill is the right way to move forward, and I urge the committee to proceed caution. Thank you.
Thank you. Representative Schmidt, for a question.
Thank you, Madam Chair. So you've already raised the issue that I was going to address, and that is a study committee rather than make or break at this particular point with this particular bill. Was that issue? Did you raise the issue before the Senate on this bill?
I was not even aware of this bill when it came through the Senate. I guess I was focused on my bill that I thought was the right path to move forward. So I did not attend the Senate hearing.
Okay, thank you.
Are there Representative Sellers?
Thank you, Madam Chair. So we already have a continuing resolution for a solution to a failed budget. And now we want to give them 240 days. So Representative, I appreciate your no response, but let me speak, all right? Thank you. What I'm getting at here is, I believe we already have a continuing resolution as a means to keep the government open and going. Would you agree with that? Is instead of we needing this bill at all?
I unfortunately disagree because we don't have an existing continuing resolution that always falls into place. That must be passed by the body each biennium. And as we've discussed last June, we got very close to not being able to pass the continuing resolution. So it's not like it's an existing answer that can always plug in. The fear is, that, as this bill states, is if there's no budget passed and there's no continuing resolution passed. And we heard that has happened.
Representative Slotchie?
Thank you, Madam Chair, and thanks for taking my question. I think one of the things that I haven't heard addressed is the balance between our responsibilities as legislators and our, sort of how easy our job is. Passing a budget is very difficult, I think, as we saw this year. And what I fear is in these bills that we see it becoming easier to do this job. We're not held to account for the decisions that we make. And in addition, creating sort of unintended consequences. Would you agree with that assessment in terms of this bill? And do you see any other sort of unintended consequences, such as if the governor doesn't like the bill, can the governor veto the bill and declare a state of emergency? And does that, in your mind, grant the governor additional authority over the budget? Thank you.
Thanks for that question. I agree with you. It's hard. I sit on House Finance. It is a slog. And when you think you actually get somewhere, all of a sudden you find out we're not as close as we thought we were. Something comes in the committee of conference literally the week prior, and all of a sudden everything, turns upside down. It's hard work, and it's work that we have been elected to do for our constituents here. And I agree with you. I agree that it gives a tool to the governor that they don't necessarily have now that could be used in ways that does take away our power, depending on, who's in charge, where negotiations are happening. I think it is concerning.
Thank you. Do a follow-up or you good? Are there any further questions from the committee? Thank you very much.
Thanks. I appreciate your time.
Thank you. Next, I'll call Mark Mangianello. I apologize if I couldn't read that correctly. Thank
Mark
you.
Manganello, Bureau of School Finance, Department of Education. I'm passing around a memo for you all to read. This bill was not on the Department of Education's radar. I was reading the Gen Core calendar, and this one caught my attention. And I looked into to see that the Department of Education is not included as an essential, essentially an essential service. And if there was a declaration, the Department of Education would essentially, I guess, would not be operating. And in reading the committee hearing minutes, I was not at the Senate committee hearing minutes. It was discussed how the Department of Education issues a lot of grants in September. That is correct. Adequacy goes out September 1st. That's a $1.1 billion grant allocation. Some of that is swept. But that calculation is made. EFAs go out September 1st, and charter school aid goes out mostly in August or September. It depends on when the charter school opened, had their first day of school. But to make those grants on September 1st, we have to do a lot of work all summer long. So as districts end their school year, what they're doing is they're submitting data to the state. So 150,000 district public students is submitted through a data submission. And essentially what they're doing is they're billing the state to be compensated for educating those students. That is true with EFAs, that is true with charter school students. And so we do work all summer long to ensure that data is accurate and that we've accounted for every single student that is entitled to state funding, either through district, charter, or EFA state funding. And so we need to be operating to do that work, to receive that data, to vet that data, and to be ready to make those grants on September 1st. So I'm the Bureau of School Finance. I don't represent the entire department. I can only speak to school funding and school financial reporting. And my operations would not be able to, I wouldn't be able to make those grants come September 1st if we were shut down for an extended period of time. Actually, we usually ask districts to certify around mid-July. And so they certify, and then hopefully we have no deconfliction in the data, but then we continue to evaluate and vet the data to make sure we make accurate calculations and that school funding is known, predictable, and stable starting the school year off. In looking this over and talking with Commissioner Davis, I noticed that DHS has language in there that says the commissioner has some authority to ensure operations exist to the point where no New Hampshire resident is negative impacted. So I have a provision there if you want to add a clause Z that basically pretty much mimics the authority that the DHS commissioner would have under this proposed bill. That would allow us to continue operations and ensure no student was negatively impacted.
Thank you very much. Are there any questions from the committee? Seeing none, thank you for that insight. We appreciate that. Seeing no other pink cards, I'm going to close this hearing. This next hearing we're about to have is one that is normally a topic that would be heard in Commerce. So I'm just going to run next door to see if there's any of those committee members that want to sit here so they can ask some questions. And I'll be back in maybe 60 seconds. There we go. Thank you. If we can get all the pink cards passed up this way. And I will open the hearing on Senate Bill 669 and recognize Representative Grota to introduce the bill for the sponsor.
Thank you. I'm Representative Jackie Grota. I represent Rockingham 24, the towns of Ryan, Greenland. And I was asked by Senator Perkins Coker to introduce House Senate Bill 669 relative to on-premise licenses for licensed barbershops and salons. This bill was the request of one of her constituents and a small business owner, Nathan Riggs, who is here today. This bill seeks to tweak last year's Senate Bill 187. Originally, Senate Bill 87. Senate Bill 87 envisioned control cocktail services in barbershops and salons, and by the time it was signed by the governor, the original intent was replaced with a complimentary service permit costing $100 a year, prohibiting any sales of measurable tax collection. Prohibiting any sales or measurable tax collection. Senate Bill 669 was introduced because most small business owners see no incentive to pay for a permit that forbids them from generating any revenue from alcohol service, but subjects them to the same Liquor Commission oversight as full-service licensees. Service is limited to 1 drink per client per visit, and this is about offering customers a refreshing alcoholic beverage, not creating a loophole for barbershops and salons to run bars. The Liquor Commission would be in charge of enforcement and producing a report to examine how many businesses take advantage of this program. We rely on local businesses to drive our local communities. Still, this bill would expand opportunities for our local barbershops and salons, and I ask you to support on a positive motion Senate Bill 669. This is her request. And with that, I am done with introducing the bill, and I believe there are people here who were involved with writing the bill that will help answer any questions.
Thank you very much, and thanks for introducing the bill on her behalf. First, I'll call Chairman Hunt from the Commerce Committee to speak on this bill.
Thank you very much. For the record, I'm in opposition to this bill.
Yes.
We'll start from the beginning.
Sorry, if you could do the introduction as well. Sorry,
Excuse me,
I threw you off.
I'm
because...
John Hunt, representing Ringe, New Hampshire, for 40 years, evidently. This issue first came to my attention as chairman of the Commerce Committee almost 15 years ago. And that was that we were finding bridal shops were giving away free glasses of champagne. Under our liquor statute, it starts out right at the get-go that nobody can sell or give away alcohol without a license. And I used to joke to the committee is that we have a rule of licensure. And obviously, being EDA, you probably know this rule, and that is that we create these rules, the licensure, simply so that when you're bad, we can take it away from you. Because sometimes maintaining a license just means you paid your fee. There is no continuing education for a lot of licenses. But that it is our hammer as a legislator is that how do we show somebody when they're doing something wrong? How do we react? Well, we have that agency pull your license. So what occurred was back then, and that, I went back and forth and we were deciding, we said, well, there are a lot of bridal shops and men's clothing stores, a lot of potential that we can give away. And of course, we did know that there were plenty of hairdressers. Barbers, I didn't really know back then. So as we turned around and get up to last year, we finally said, okay, let's address this issue once and for all, because technically anyone who sold alcohol in without a license was committing a felony. And so we said, well, obviously the Liquor Commission wasn't enforcing that felony, but we needed to address that issue. So we decided that we were going to give a license to any of these barbers and the hairdressers. And yes, it is true if you read the statute, it includes tanning salons, that we would give them the right to give away a free drink, because that's what they were doing. Bridal shops, we can have a little glass of champagne and get excited about the dress. The question came up was, well, that there was some facilities out there that actually were charging for that drink. Well, that flies in another very critical policy when it comes to liquor laws in New Hampshire. And that is, nobody can sell alcohol. This means beer, wine, distilled, except the Liquor Commission. Nobody can sell alcohol without a food requirement. Okay? Now, this food requirement, if you start with the grocery stores or the convenience stores or your little local gas station, that, yes, there's a statute that requires them to have $3,000 worth of food. We actually chopped it down to $1,500, but it was for $3,000. We chopped it down, that there must have food requirements. And I remember in the old days, there used to be one little refrigerator that had bacon and eggs and milk and orange juice, and you say, boy, nobody's ever buying any of that. So when Max Abramson, a former rep, put a bill in to get rid of the food requirement, I did go into all the community, and I found that, no, they don't necessarily have the eggs and bacon anymore. They just have frozen waffles and sausages. So they met the breakfast requirement. Okay, so all these off-premise licensees have a food requirement. But more importantly, it's the restaurants or bars. We do not have bars in New Hampshire. We have anyone who's a restaurant can get a cocktail license. And the cocktail license, which is going to be the full price of a liquor license, assuming you're going to sell cocktails, is allows them to stay open after 9 o'clock after the food has closed down. So they can stay open and not have food, but then be able to still sell liquor. So when it came to the issue of whether we were going to allow bridal shops to sell booze or beer or wine or sell the champagne or whatever, no, the simple answer was no. We weren't going to allow them to do that. We would allow them to give that free drink. If they really want to get paid for that free drink, they could probably hint about maybe getting a better tip that night or that day, because a lot of people tip their hairdressers, okay, their barbers. But that at the end of the day, the policy was we didn't want to muck around with the food requirement, which is very, I would say, almost every session we have issues wrapped around that. For instance, when it came time to allow beverage manufacturers, i.e. the beer stores, beer manufacturers, when they wanted to be able to give samples. And we said, okay, you can give samples. And then they said, well, we want to charge for giving the samples. And we said, no, you can't really do that because you're not going to have a food requirement. But we'll limit it, okay? We'll give it down that they would do it, but only one drink, okay? They can only give away one drink. They can only sell one drink. And then we came back with, oh, we want to sell 2 drinks. Okay, then we put a food requirement on them. So everybody has a food requirement in the end, except this bill is suggesting that they can sell alcohol without the food requirement. And that flies in the face of our whole history upon what we do in the Commerce Committee when it comes to liquor laws. And I'd be more than willing to answer questions.
Thank you very much for that history and insight on liquor licensing in New Hampshire. Representative Schmidt?
Thank you, Madam Chairman. So it's my understanding that one of the requirements is that a restaurant or a bar, I understand your explanation, has to have 50% of its revenue has to be food.
Right.
In other words, you can't come in and get drunk legally. You have to have.
They have to have a food. They have to sell food, and it can't be just nominal. But that's only it's a de minimis amount in terms of how much business they do. Is that 50% rule? But because there is 75,000, it is a cutoff. So it's not. So, but yes, it is true. The Liquor Commission will expect if it's a small bar, they will be looking to see what the food sales.
Thank you.
Thank you. Are there other questions from the committee? Representative Bailey and then Representative DeVries.
You pointed out that this usually comes before Commerce, which is probably more intended to deal with this kind of
This
thing.
bill would have been hoped to,
If we were to just go rogue and pass this, does it just blow the whole tier 1 and tier 2 and food and everything?
I would be asking permission from the speaker that I could do something that we're not, as chairmen, we're not supposed to do, is to get down on the House floor and try to convince people not to pass this bill.
Okay, thank you.
Representative DeVries.
Thank you, Madam Chairwoman. And thank you for coming in on short notice, Chairman Hunt. I guess and I have a short history of understanding about how these laws may have come to be. But could you educate me about what the philosophy is? And I'll tell you that I have a little bit of a bias here because it sounds to me like typically you're trying to make sure that people have food so that people aren't getting inebriated. That makes a lot of sense. But this bill has a provision in it, and most salons and barbershops are small businesses. And you talked earlier about the licensing being a hammer, if you will, of government. And I would see that as naturally going against my friends on the other side of the aisle are not big fans of big government. This seems like a pretty easy carve out. So is there a philosophy behind it that I'm not understanding? Because this sounds like it's supportive of small businesses to me, if there's a limitation of one drink to be sold.
For
Thank
instance, I
you.
put in a bill this year to allow these small beverage manufacturers to actually carry somebody else's product, which we didn't let them do. Okay, so that if you were a cidery, made cider, that now if that bill passes, you'll be able to sell beer and wine. Okay, here's the real rub. This would be a camel's nose under the tent. If we were to simply say, okay, this group of people would be okay, where's the end of that? Everyone else, every other business, anybody else would then come back and say, you're giving it only to because they are barbers, they have, or tanning salons, but why are you limiting it to that? We will be flooded in the Commerce Committee, assuming the bills go to the right committee, that we would be flooded with these requests for every different kind of business is going to say, well, gee, I want to sell booze. So let me tell you another story, okay? And when you've been around 40 years, you got lots of stories, okay? New Hampshire is very unusual in the sense that we do not restrict the amount of licenses that we issue. Most states, let's just take our friendly Massachusetts next door. Massachusetts does have bars. They do have bars that don't have any food, but they limit the amount of licenses that are available in each town. Okay, so when it comes to where we come up with this food requirement, clearly part of the food requirement was that everybody thinks if there's food, if you get drinking, you get food, it's going to be a calming effect to the influences of alcohol. But more importantly, and I've always said I would love to have been in the room back in 1934 when New Hampshire decided to legalize alcohol. And ironically, the constitutional amendment, the 21st Amendment, did not say anybody can sell liquor. It basically said each state can have its own law. Okay, and some states were pretty dry, and we actually have dry communities here in New Hampshire. So the concept of how much alcohol we're going to allow and what we're going to do, and when they're all sitting around in that room back there in 1934, and they're saying is how are we going to sell this, how are we going to distribute it, and they made the decision that because they knew there were plenty of beer distributors who were selling soda, they were doing everything. They were still around, and they very much wanted to be back in business, okay? And they said, okay, we'll create this thing called the three-tier system. In the three-tier system, there are manufacturers, there's distributors, and then there's the retail end. And in this model, none of one could do what the other one was doing. Each one had their separations. But in this model, we made the decision that anything that is 6% or less of alcohol would be delivered by the beer distributors, and that the beer distributors will collect the beer tax for us. They were collecting the tax for us, and they would, but that the alcohol could not exceed 6%. So that's why even wine coolers were able to get into there, and beer. Then slowly but surely, over the years we chipped away at that. Okay, but that makes the Liquor Commission a separate, is now the only one that can sell high alcohol. And no, they didn't have the food requirement. But at the end of the day, food was always an element. And there's no doubt in my mind that when they were sitting there trying to figure out who was going to sell beer back in 1934, it was that every town had an IGA, village grocer. And they said, they got food. Right? They're the grocer. They're the little convenience store. That was back, long before gas station convenience stores. The IGA, I don't know if maybe you're old enough to know IGA. Sorry. Okay. So that IGAs, okay, every town had one. Perfect. They're going to be the ones who are going to sell the alcohol. And so they basically created the law around what IGAs sell, food. And so that's why it was put. Now, you take the restaurants, the hospitality industry, they're very upset about this bill because they spend thousands of dollars, hundreds of thousands of dollars to build out their kitchens. And then all of a sudden you're going to have next door, you're going to have a guy who's cutting hair and giving them and selling beer or selling a cocktail. And right now you can't, there is no cocktail license at 480, which this is. Okay. Right now our cocktail license is $1,280. So this bill really upsets the balance that we had. We still
Thank
have,
you.
I hope.
And Representative Slotchie?
Thank you, Madam Chair. Thanks for taking my question. Is the food requirement in your view sort of a end run around preventing nuisance situations, or is there some other root cause in your opinion? And an additional question: you just mentioned that the guy next door might not like it if I start selling wine. Is the purpose of this regulation to protect the guy with a big kitchen?
No, it would not be to protect him. They're just saying the unfairness of it. They would say is, okay, fine. If you think it's okay for someone to sell, beer without the food, then free us. We would love to get in. We would love to get rid of the kitchen. We would love to that new restaurant we open up not have to have a bar. I mean, not to have a food, just to have a bar only. And believe me, there are plenty requests for, people want to sell beer, sell alcohol. It's a high margin item.
Representative Bailey and then Representative Sytek and then DeVries again.
There must be something I'm not understanding. It's like, hypothetically, if I had a movie theater, which I don't, and I'm vending popcorn and candy,
right?
That entitles me to serve drinks?
Actually, you have to get from the commission exactly, but we have lots of limitations and certain different licenses. So I believe theaters might have a different license because I know that they do sell drinks and
Okay.
Yes, you can. You go to the Palace Theater, you can definitely get a drink, but I know they also have food. But I would say that, and I can't speak, because I think there's like 34 licenses. But I know, for instance, we allowed, if you were a tennis club, as long as you had 2 tennis courts, then you can get a liquor license without the food requirement. If you have our pool house, the pool tables, you have to have 10 tables. Or 8 tables, and then you were exempt from the food requirement into the cell. So there are some, and I would say there are always exceptions to the rules. My concern about this particular bill is that that we just pass enabling them to give away alcohol. That they literally come in even before the ink is dry on that new bill, that new law, and come in and say, no, we don't want that. We want to sell it. And my understanding, there is some people, even here in Concord, have a barbershop with a full bar, and that kind of flies in the face of our statutes about bars should have food.
Thank you. I was unaware I could get a drink at the movie theater.
Thank you. Representative Sytek?
Representative Hunt, this is a morass here. Just because you have food available doesn't mean somebody's not going to use it.
That is true.
Shouldn't the whole food requirement issue be examined on its own? I mean, there's these tennis courts, it just sounds incredibly complicated in efforts to get around the food requirement, isn't this is like the Sunday blue laws.
It is Byzantine. I have to agree with you. It is complicated. In terms of, as been the chairman of having liquor laws coming for the last 20 some years, thanks to your wife, as a matter of fact, that she made the decision that the liquor bills would come to Commerce. I would say each year we are chipping away, we are broadening it, but that there are certain fundamentals that we got to hold up. We're not too crazy about the 3-tier system. We do have brew pubs. that actually brew the beer and sell the beer there, and that's a totally trampling on the three-tier concept. So I would say we have chipped away with it. I agree with you that it sounds like a morass, but that if you just opened it up and just say that anybody and everybody could to sell alcohol and not have any restrictions in terms of the food requirements, or not have, some expectations of some limits, you will have every restaurant, everyone who's already spent all that money in having their facilities up in arms, telling you how could you let that happen.
Representative DeVries.
Thank you, Madam Chair. Just wanted to follow up because earlier when I asked a question, you said that if this bill were to come out of this committee with a recommendation, maybe not those exact words, it'd be like a camel sticking his nose underneath the tent. That then you went on to talk about all of these other exceptions and that there are 34 different licenses. And could you explain to me why it's important to serve alcohol at a tennis club possibly without food, or a pool hall without food, and how those are different than the personal grooming that happens and the social element that's happening at why is that the area where you feel that you believe that we should draw the line as opposed to personal grooming?
Yeah, one of the unusual aspects of lawmaking in general, but we certainly see it in the liquor, and that is once you give somebody a unique license, once you give them something, it's hard to take it back. Okay, and I would say is so that the history of commerce since I've been chair is that we are always broadening it. We're giving more capabilities. The fact that all these unique licenses that I've just mentioned happened before I was there, okay, and I can only explain that the wisdom of the legislature at the time was that these little chipping away was okay. It was a minor situation. They didn't see huge amount of tennis courts getting built or pool halls opening up. And so you could say, well, that's the same thing with, the hairdressers. Tanning salons, I don't know if you really, that's in there. But the idea that, how much you want to open it up, if you just simply take this small group and say they're okay, all I can say is, don't forget, when we were originally brought attention to this issue, it wasn't the hairdressers, it was the bridal shops. Okay? So the bridal shops are going to be in tomorrow. If we pass this bill, they'll be in next year saying that we should have the same privilege. And then bridal shops, and then you have all clothing, men's clothing. I mean, just, shoe stores. Or anybody where sometimes you have to sit and wait sometimes to find somebody. They'll say, "Wouldn't you have a drink?" And all we're saying is, and the irony is, they say, "Well, it's only one drink." Well, if it's only one drink, why do you need to charge for it? But if it's only one drink, don't charge for it. Just give it to them. Or next year they'll be back. They want 2, 3. They want.
All right. Well, thank you. There another question from Representative Zlotchi.
Yeah, the more I hear, the more I think about the previous question I asked you, is the idea of is the food requirement, was it instituted to prevent sort of nuisance behavior, and would we benefit from, instead of targeting, having a proxy for nuisance behavior, just say if you're creating a situation that's a problem for your neighbors, we're going to yank your license, and the food requirement it might be a clever way to try to achieve that, but it may be perhaps outdated.
I truly believe they did believe that alcohol should be sold with food. That it should be, it should be a way to help that people don't drink too much. If you got to pause to eat. So yes, it's a nanny type issue. I would agree with that. I come here and saying, as someone who absolutely every year we're chipping away at some of this nanny element of our liquor laws, but this one is as an institution. If we were to if you start allowing businesses to have a license that did not require having any food, it would be a storm. of having to deal with those bills.
So simply, sorry,
One more follow-up.
thank you very much. So simply removing the food in your mind would cause you to oppose this on the floor of the House.
Yeah. Well, I would cause it simply because that the fee is too low. The 480 is way too low to give away distilled. Okay, and B is that we had just passed another law that says that yes, they can give it away. Why, to say is okay. Well, now let's have them sell it. The difference between giving it away and selling it, I don't know how there's any difference in the economies, in terms of the state. I mean, I guess we get some room and meals tax. I mean, I don't think he knows he has to collect rooms and meals tax when he's charging for it. And that requires you, I don't know if you know about that, you have to file every month. And even if you didn't sell anything, you still have to file, but it's just another, you're taking on more bureaucracy when you start to sell things. And like I say, it is my fear is that every business is going to say, I want that license, especially at the cheap price of $4.80.
Thank you. Representative Sytek?
And by the way, the reason why it's the $12.80 for distill is because the Liquor Commission pays more attention to those facilities. Okay? In other words, when you give away whiskey or you're selling whiskey, you're going to have more apt to have somebody who's had too much than someone not. And you say, but it's only one drink. What's the harm in that? It's just the camel's nose in the tent.
Sorry, and one more follow-up from Representative Slotchie.
Thank you, Madam Chair. And I'm curious, why would it be a bad thing if every business had one of these licenses? What, in your opinion?
Because we don't have enough enforcement to keep an eye on all these establishments. Or it's, you have to, Liquor Commission, that the fees are real. And yes, they really are enforcement. And yes, they do come in and check on anybody who is, in these facilities. And you have to remember, there's two pieces of what the commission does. One is, of course, over-serving. But more importantly, somebody who's under 21. So, that these establishments are risking their license, and I would beg to say it's kind of interesting that we're building in on the license that they have, their professional license. So which license are we going to take away from them if they sell to somebody under 21? I would say is, if you really want to pass this bill, tell them they lose their professional license also if they sell to somebody under 21.
Thank you. Are there Representative Long?
So I get that we currently don't have enough enforcement for every business in the state to have these licenses, but I thought the point of the licensing fee was to pay for enforcement. So is the price of the licenses here wrong for paying for the amount of enforcement that would be required for this expansion?
I would say yes.
Follow up?
Follow-up.
What would the correct licensing fee be?
Right now, the correct licensing for sell distill is $12.80.
Thank you. Are there further questions? Representative DeVries?
Thank you. Very quick. To be clear, that other cocktail license at $12.80 doesn't limit the purveyors to one. It doesn't to one drink. So there is a differential there.
But again, at the end of the day, we have more problems with establishments that sell distilled liquor than with the beer and wine. Okay, so we do have a cheaper license for the beer and wine. So, but at the end of the day, yeah, you got to, you do the math. If how far this bill goes, and if you give it away too cheap, right? You're the $4.80. When it comes back, you say, oh, well, we really decided that we want to expand it and let them have more. And now you're gonna change the license. Then you're gonna have them all come in and protest that that you're taking away what they just did, what they just got. I mean that's the nature of legislation, is that once you give that anybody that entitlement, they're going to fight like hell to keep it.
Thank you very much. And thank you for taking time out of your committee to come bring that insight.
My pleasure.
Thank you. Next, I'll call CJ Haynes from the Brewers Association. And anybody who wants to speak, please make sure you filled out a pink card and sent it out.
Hello, thank you, committee. My name is CJ Haynes. I'm the executive director of the New Hampshire Brewers Association. So I can actually kind of elaborate a little bit on firsthand knowledge of what just happened in some of the context of what it is that's causing the issue with parity. And when it comes to our brewers in the state, we do have one license that is almost an apples and apples to comparison to what you're being presented with in this. In that currently a beverage manufacturer that does not serve food is only allowed to serve 1 pint of its own beer that it produces in-house. If they want to serve more than that, they have to meet a food requirement. So 1 for 1 here, we're talking about the same thing. However, we are not talking about the same thing in the sense that a salon would then have the ability to serve a glass of wine or a cocktail. My breweries, which I represent over 80 of them in the state, only have the right to serve one of their own product manufactured in their facilities. That means that if a customer comes in to enjoy their tap room and sit down with their friends, what if their friend doesn't drink beer and they want a glass of wine? Our breweries can't serve them that right now. So if they were to go into a salon, it creates a situation where they could get a glass of wine, they could get a cocktail, they could get a beer. But in this matter, wine manufacturers and distilleries that do not serve food also can only serve one of their own product. So when we're looking at another industry, that's personal care industry that does not rely on alcohol sales to facilitate its business, they rely on personal care to bolster their sales. They don't rely on alcohol sales for that, where we're going to allow a situation that that industry could serve more and offer more to its customers than the manufacturers that produce said alcohol types in the state are allowed to do right now. And that creates a matter of one that creates commerce, which then should, in essence, create parity. And that is why we're in opposition of this bill, in the sense of if we are unable to do what this can do, we feel that the price of all the licenses should either A, be all the same price, meaning that if we, right now, we pay $480 if we want to serve more than 1 pint. And that is only for beer and wine. If we want to serve a spirits, we have to pay $840 to have that right. But both of those still require that we have to have in-house food to do that. Further, we're concerned that this will take some of the administrative burden that's happened throughout the years. Just to give context, I've been doing this for 10 years, and I was initially one of the few people that sat before many of these committees in the last 10 years to ask for the right to serve a pint. When I first started, breweries did not have the ability to serve a pint. It took us nearly 10 years to get to the point now where we're offering additional things. But along the way, all of that required food as part of the equation. Even when we changed the law 5 years ago, it still instituted that if we were to serve 2 pints, even if it was from a third-party food provider, we could only serve the 2 pints in those locations. So all we're asking for in this situation is that if we're going to create the precedence of creating additional license types, we feel that the fees should mirror the same fees that all of us have to pay. There should be no exceptions. There should be no carve-outs. Everyone should pay the same fee for the privileges that they are awarded. And I'm happy to answer any specific questions.
Thank you very much for your testimony.
Sure.
Are there any questions from the committee? Seeing that, I think we got Representative Bailey.
If the food is just kind of a fig leaf based on what they thought in 1934, couldn't you just hang a pair of scissors next to the bar and cut a hair and say, okay, that's the new fig leaf.
And honestly, at this point, what you'd be looking at is that it would be less expensive for my breweries to get a salon license than it would be to operate a full restaurant. So what's to stop a brewery right now from saying, okay, I guess I'll just open a salon in the back of my brew house?
Follow up, and then Representative
And-
Slotchie.
Given that it was almost 100 years ago, they decided you need to have food with a drink. Is there any science for that whatsoever?
There's conflicting science that always happens in that argument.
Yeah.
But I will say that progressively, even in the last 5 to 10 years of this industry, we have noticed that there are almost 100 breweries in the state. And of those 100 breweries, nearly 75% of them have food at them, because the experience that a consumer wants when they come to an establishment that serves alcohol is to also continue their stay by adding food as part of that experience.
Thank you. Representative DeVries.
Thank you, Madam Chairwoman. Redundant, Madam Chair. So is your objection, would you object to this bill if the financial piece were the same as the breweries were paying?
I would object on the basis that my breweries cannot serve alcohol, meaning spirits. They can only serve beer and wine. So the distinctions have to be the same, is if they can only serve beer and wine with a $480 license, then salons should only be able to serve beer and wine and one with that $480, in addition to the food requirement.
Follow up.
So the 480 limits to beer and wine. I'm saying if this bill were altered to up the annual fee to the cocktail license, would you object to that?
No, but I would say that it still have to meet the food requirement that we have to.
Thank you. If this passes, we'd be looking forward to the beers and brews at all the breweries, possibly. But market opportunity. Thank you very much.
Thank you.
Next, I'll call Nathan Riggs, please, to speak for the bill.
Hello. How are you this morning? My name is Nathan Riggs. I'm a first lieutenant logistics officer in the New Hampshire Army National Guard with 15 years of service across 3 branches of the U.S. Armed Forces. And I am a licensed barbershop owner in this state. Last session, SB 87 was introduced with bipartisan support to let barbershops and salons sell alcoholic beverages to customers. But it was significantly weakened into a $100 license that only allows complimentary service, giving away product at a loss with no ability to generate revenue. SB 669 corrects this with 2-tier framework. Tier 1, $100 for complimentary service, and Tier 2, $480 for actual sales. Each limited to 1 drink per customer per appointment, with full record keeping, mandatory liquor commission training, and an annual reporting requirement to the legislature. With over 2,200 licensed shops statewide, even modest Tier 2 adoption would generate significant new license revenue and incremental product sales through the state's controlled distribution system. New money for the liquor fund at virtually no cost to the state. 15 years in uniform taught me that service doesn't end when you take off the boots. I built my business to serve my community, and as a logistics officer, I see this bill the way I see any other supply chain problem. We have licensed businesses, the consumer demand, and the state revenue system to capture the benefit. SB 669 simply connects them. This is not about turning barbershops into bars. It is smart, low-cost deregulation with strong safeguards that trust New Hampshire small business owners. Grows state revenue without raising taxes, and gives veteran entrepreneurs and thousands of other shop owners a real tool to compete in the modern market. I respectfully urge this committee to recommend ought to pass.
Thank you. Representative Slotchie.
Thank you, Madam Chair, and thanks for taking my question. We heard previous testimony about some issues of fairness that this bill might raise with establishments that are operating as breweries. Would you be opposed to us addressing their concerns in a possible amendment to set the playing field more equally across industries?
Sure. So what I heard was that they are only allowed to serve. I don't know their regulation. From what I heard, it was one beer per, depending on the license price. Is that what it is? Yeah. I mean, that's like a whole separate entity. I'm not brewing beer. I'm cutting hair and giving my clients something that they would appreciate. And it's not only helping my business or the other salons and barbershops, but it's also helping the state. And it's comparing a brewery to barbershops. I mean, I can see where they were talking about clipping one hair and then serving, but that means, I mean, my barbershop charges a lot of money for a haircut. I'm in Portsmouth. I have high rent. So I'm trying to support that. So if somebody comes in for if I'm clipping one hair, I'm charging you $55 for a haircut. That's expensive. And then you get your drink. It doesn't make any sense. I don't think that's going to occur. And if it does, jackpot, like I'm doing all right. It seems a little ridiculous to think that that would be the case, but, maybe they have a claim to that. I'm just not well versed in what they have for regulation. So.
Thank you. As part of that is the cocktail license is the $1,280 a year and the food requirement. If that's something where there was a food requirement and the cocktail license, is that something that you would consider in order to be able to sell the spirits in your barbershop?
I investigated that. I called the liquor commission and I talked to them and I was like, hey, is there any way around this? And the woman who I spoke to stated that I would need a full kitchen. I didn't go into the restaurant business. I went into the barbershop business, and I don't have $200,000 to put in a full kitchen for what they're asking. I did ask if there was any possibility of outsourcing to other restaurants in the area to maybe benefit them, have something that maybe was frozen and could be cooked in certain ways. But again, that's not really what I got into business for. So maybe, it seems like another uphill battle there, but if that's what's felt, and then the cost, $1,280, you're not gonna, adoption rate's gonna be nothing for one drink, I mean, it doesn't seem feasible for a business like mine, or other barbers and salons, but, I can't speak for them. I just know that 480 is, I feel, pretty reasonable, for what it is. And it's 1 16-ounce beer, 1 6-ounce glass of wine, and 1.5 ounces of alcohol. And I do not want to be a bar. And I don't want to impede restaurants. They help my community. So they help our businesses. People come to Portsmouth for the restaurants. And then usually what happens is they'll come to my barbershop and then they'll go out to eat. And they'll go out to see town, and maybe go to another bar, so.
Thank you, Representative DeVries.
Thank you, Madam Chair. Is this something that you're aware of that is allowed in other states, the sale of alcohol at barbershops and salons?
I'm aware that they have separate licenses, but it varies depending on the state. So I have researched that. There are those possibilities in other states.
Follow up.
Thank you. Could you educate us, for those of us who have never been in the salon business, tell us a little bit about your business and why it is that this is important to the health and of your business or making money?
Sure. I mean, it's the barbershop is community, just like salons or anything else. You're coming into the barbershop and I talk to so many people and other people talk to other people. They walk in with their kids, they see, other families and it's a great meeting space because everybody needs a haircut. Everybody's from different walks of life. They all come in. It's pretty great. This particular thing is when somebody's had a hard day at work and they want to relax and they're coming to get a haircut and they're coming to talk to me and they want to enjoy their time. It's an added benefit to them, so it just adds to the experience, I mean, that's mainly why I think it's not, that it is a good thing. So,
Thank you. And then I have one last question for
Sure.
you. We had heard we had a bill that passed, and now this is just trying to expand on it. In looking at your testimony and what you've said, what you're trying to do is push for the policy that was initially introduced last year with Senate Bill 87.
Correct.
Because you believe that the policy should be as full and expansive as it was introduced and not what was actually passed.
Right. So it was pro-business. I mean, it's small business, I mean, in the end. And then it reached the House. I watched it all the way. And then it went to the House and it was cut down to that. And so it just inhibits our ability to make revenue off of the product we're purchasing to give to our clients, you know, so.
Okay. Thank you for helping us have that understanding.
Appreciate it.
Thank you very much.
Thank you.
Next, I will call Mike Summers from the New Hampshire Lodging and Restaurant Association. And sorry for us working through lunch. Didn't quite get my timing right on each of the hearings.
Good afternoon, Madam Chair, members of the committee. For the record, Mike Summers. I'm the President and CEO of the New Hampshire Lodging and Restaurant Association. This might be my first time testifying before this committee ever. For a little context, our association is about 1,300 licensees from all over the state, to include restaurants, hotels, campgrounds, breweries, attractions, et cetera, et cetera. We are here in opposition to this bill. I can certainly appreciate Mr. Riggs' points, and I understand why he's pushing for this, but our industry has some grave concerns about this. So, and I just want to hit on a few key points that have been mentioned already, and then a couple of additional points. But I want to go back to what Chairman Hunt said, and he mentioned how, you know, this activity of salons and bridal shops and barbershops, et cetera, giving away alcohol has been going on for 20 or 30 years illegally. It's a Class B felony. And so, you know, when the legislature then rewarded them with a license last year where they could give it away for free, but within the context of the law, because by the way, none of this was ever enforced. And I testified before House Commerce last year, and I did say to them that, you know, if we're only going to enforce some of the laws, we've got a few we'd love to put on the table for consideration. Chairman Hunt didn't think that was super funny, but anyway. But ultimately, we are concerned about this. A few other things. The food discussion. This is a time immemorial discussion within our industry and within, and particularly with House Commerce. So our industry, we have been required forever to have full-blown kitchens in our establishments. And we are talking kitchen, to put in a kitchen nowadays with the Ansel system, the Hood system, et cetera, these are in the hundreds of thousands of dollars. These are not small investments by these small businesses. And so when there is an initiative that proposes to allow licensing for full-blown bars without any food requirements, it obviously puts us at a competitive disadvantage right out of the gate. Last year, there was a bill that was killed by the legislature that would have allowed for a tavern license, and a tavern license would have been just a bar. No food requirements, nothing, just a bar. So now consider that we were opposed to that simply because all of our members already have these hundreds of thousands of dollars worth of kitchens that they've installed. They have inventory, they have staff that has been trained, they have all these requirements that they have to meet from the food licensing side. And now you're going to give us a competitor who can open up next door, literally put a board on some cinder blocks and stack alcohol bottles on it, and they're open for business. That just doesn't seem fair and equitable to our industry. There is a requirement around minimum food. So for our restaurants, for example, they have to have at least 50% plus one has to be food sales, or a minimum of $75,000 in food sales. And I'm sure you've all dined in restaurants recently. You can get to $75,000 in food sales pretty quickly with prices in restaurants these days. Don't hold me to account on that. At the end of the day, it's all driven by the cost of doing business. There's also a public safety concern. This bill, when it was first filed last year, and again when it was filed in the Senate this year, had a requirement that these salons and barbershops, et cetera, all of their staff who were going to be involved in selling alcohol would have to have some training. In our industry, people that come in and work in our industry, we do a lot of internal training on a regular basis. It's essentially to mitigate the liability of the business should something happen, God forbid. This amendment that happened in the Senate before it was sent here stripped out all the training requirement. They just have to have the manager of the business who is trained. And I will just say that there are specific trainings to recognizing visible intoxication in individuals, and under this particular license, they would have the same standards we have to meet, which is that if you cannot serve to anybody who is visibly intoxicated or a reasonable prudent person would know is intoxicated. But the visible intoxication, signs of visible intoxication, is a training process that you have to go through with your staff. You don't just, granted, there's the flagrant and obvious ones where people are falling down, those kinds of things, but there are subtle signs of intoxication these people need to know about. So at the very least, there should be a training requirement put back into this this bill if you decide to take action on it. You know, I get the small business argument about this supports small businesses and gives them freedoms. Here's the challenge for us. In the testimony we just heard from Mr. Riggs, yes, people may come to a place like Portsmouth, they may get a haircut, they may have a cocktail. But then if they're likely going to go to the restaurant next door down the street, we have lost that sale. So as the restaurant, now you're essentially taking whatever the pool or the pie of alcohol sales are going to be in the state of New Hampshire, you're just spreading it out over more people, which means that the restaurateurs who have all this overhead with the kitchens and everything that they're required to have, they're in direct competition with us. So we're obviously very concerned about that. The other thing I'll say about food very quickly is, and I think the Liquor Commission will likely testify to this as well, food has a mitigating factor on alcohol consumption and absorption. So having food available, and I don't know about you guys, but after my first drink, I might not be hungry, but after the second drink, I'm usually having a snack of some sort. What that does, it takes up space in your stomach, you become full, you can't drink as much, it just slows down the process, it also slows down the absorption rate of alcohol. All of these things are constructive and good in the whole consumption of alcohol on premise. And then I also just want to highlight, you know, where does this end? So we give this to salons and barbershops. Can we get a drink when we get our oil change next? Is it going to be at the dentist's office? I mean, where does this end? And so obviously that's of great concern to our industry, because in an industry that has a profit margin of about 3%, we are now basically going to be giving away the most profitable piece of our business to everybody else in the community, which is a huge concern, obviously, for all of our small businesses. Oh, and the other thing is the restriction on one drink. It's laughable. I'm sorry, but at the end of the day, one drink is an unenforceable mandate. If somebody comes into an establishment and is only allowed to have one drink and it's going to be recorded, great. But what's to stop cash transactions that aren't going to be 2 drinks and 3 drinks and 4 drinks? And we also just heard that this is about creating community in a salon or barbershop. Well, that's what restaurants are for. I'm sorry. That flies in the face of direct competition with us. And we have built our entire businesses around the hospitable model. And so we certainly have a concern with that. And I will close with, well, one last thing. I also don't think the salons and barbershops understand the liability that they will be taking on with this. Yes, they're going to have to file monthly their meals and rentals tax by the 15th of the month. This is going to drive up their business insurances dramatically, because the liquor liability is substantially more expensive than just general business liability. And the other piece is, I will also say that alcohol sales on premise is a shrinking piece of business. I don't know if you guys have seen the Liquor Commission's numbers, but even their numbers are down, 10 or 15%. We're seeing it in our industry where alcohol sales are shrinking. So I'm not sure that a shrinking part of the business model is necessarily going to be constructive to these new small businesses. Not to say it won't help a little, but I don't see it being a huge piece of it. And I will close by saying that this is, in our mind, is a fairness issue. We have all these requirements and costs that we are required to have in place in order to have our operations, food production, food storage, refrigeration, all of that goes into it. And now we're essentially going to open this up to pretty much anybody could get a license, because I guarantee that if this bill moves forward next year, you are going to have 5 or 6 other industries that are going to be here asking for a liquor license with the same rights. So with that, I thank you for your time, and I'm happy to try to answer any questions.
Thank you. Representative Schmidt?
Thank you, Madam Chairman. So were all these arguments made before the Senate committee?
Excellent question. They were not, because in the hearing, the original version of this bill did not allow them to sell alcohol. It was still giving it away for free. In that case, we're perfectly fine if they're giving it away for free, because again, the industry had been doing this for 20 or 30 years. So if they want to continue to give it away, but it's codified as a license, perfectly fine with that. Because I think that there would be a natural restriction on how much you would be willing to give to any one customer, right? Just because of the cost of it. So we did not testify in the Senate because that was the version of the bill. And then it was amended rapidly and passed by the Senate very quickly. We did not have an opportunity for public comment on the amendment to the bill.
Thank you very much.
Thank you. Representative Sytek?
This isn't directly relevant, but did you testify, or did a typical restaurant only has a profit margin of 3% on sales?
Yes, sir. That's a national average.
That's
Yeah, everyone thinks that our industry is doing great. We still haven't recovered from COVID. I know that it doesn't look like that because you go to a restaurant, it's busy, they're on a wait, but the cost of everything has jumped up so dramatically, which you see in the menu prices. And, we're still trying to get back to staffing levels. The hotel industry specifically, they're still 10% below the staffing levels we had in 2019. So everyone thinks we're back, and I know that life feels normal, but for our industry, we are still struggling. We are still trying to figure out how to keep this thing together.
Thank you. Other questions from the committee? Seeing none, thank you very much.
Thank you very much.
Next, I'll call Mark Armageddon and Matt Culver up from the Liquor Commission.
Good morning, Madam Chair. Great seeing you.
Good to see you as well.
And honorable committee members. For the record, my name is Chief Mark Armaganian. I am the Director of Liquor Enforcement and Licensing for your Liquor Commission. With me here today is Lieutenant Matt Culver, who is our matter expert in this area and actually runs our unit that covers licensing. So he has extensive knowledge. And answer everyone, as I'm sitting back there, I'm shaking my head here and there. We can answer all of your questions, and they will be very clear by the time we're done. I'm sorry, but because we usually go in front of Commerce or Criminal Justice, it's probably worth it for me to take a couple seconds to just educate all of you on what we do. And myself. I was brought here 9 years ago from state police. I was the Bureau Commander of Investigative Services, which is your homicide unit, drug unit, and the Fusion Center, and ran polygraph also. When I was brought over here, I was, as Mike has stated and Chairman Hunt has alluded to, I was brought over to change the culture in liquor enforcement, and there was no hiding that. The face that you see today is not the face that you saw. It's almost been 10 years. It's almost been a decade that we changed everything to include we are CLIA accredited as a law enforcement agency, and we're the only state agency that is CLIA accredited. As we rebuilt this liquor commission, liquor enforcement, one of the biggest things that I heard right off the bat in talking to industry members, speaking to all of you or most of you that deal in our laws, was to be fair and equitable. And you heard that today. And we live by that on a daily basis. And it was evident when this came up. This came up during COVID. A little personal background. I'm a girl dad, sisters, and grew up around a lot of women who go to salons and partake in mimosas during their haircuts and wedding events. And Matt here actually received a phone call extending area when we helped jumpstart the industry. We actually extended or offered that to the governor's office to extend areas outside so we can jumpstart the restaurant industry. Matt received a call, sorry to speak on your behalf, Matt received a call that actually was a little comical, and it was from a salon that asked for their area to be extended. And we're like, you're not a licensee. And it resonated with me. And the way it resonated was, you have a culture here that nobody's going to step in front of. And Mike was right. It's a felony to give away alcohol as a business. So I didn't want to professionally, I didn't want to personally. I don't believe in overreach of regulation. I believe in regulating to the level of industry safety. This was one that we just wanted to get them licensed, to get them in compliance. And that was the background here. All we wanted to do is get them in compliance. And that's why you saw the nominal fee on the giving away of alcohol. That was great last session. It took, and we were the ones that brought that to the legislature. It took on a life of its own, and we weren't part of this version of the bill. Usually in our world, I can tell you from January, along with all of you, from January to June, I'm here. Now you have a name to the face, but we weren't asked for any advice on this bill and gave no background on it. It did go quickly. You have some very good questions how this came to fruition in the Senate. It came up on a single day that wasn't on the schedule. It went through, and myself, Mike, and a lot of us that would have testified did not testify on it, and it ended up in your hands. So we're here today to answer your questions. You bring up some good points on food. Food is and the way, Representative, the way you're looking at it is from a realist view, but we can talk and speak a lot on metabolizing alcohol and how food ends up being that coffee filter on the metabolism of alcohol and slowing down the absorption rate through the small intestines. I'm stealing your schlick. Through the small intestines, so you don't have that get up off your chair and you're like, whoa. That's the only way I can describe it. It slows it down to the point where it creates a safe environment to consume alcohol. Without that there, you're asking for trouble. So at the end of the day, we always push our food requirement. We try to be extremely fair about that food requirement. There are a lot of ways to get to that food requirement. And at the end of the day, there are thresholds that are in place by the legislature over the years prior to my existence that were there usually because of incident specific issues that were probably testified to back in the day. And as you know, legislation is never changed by something good that has happened. It's probably something negative. And in our world, negative is usually death resulting. So, and we take that near and dear to heart. We committed to protecting the 603. I say it all the time. That's my job, to look over the vulnerable age group. And all of us that decide to go to one of Mike's association's establishment or one of the salons or barber shops, and we consume alcohol in a safe manner. So with that, and we will leave ourselves open for questions, but I'm sorry. I wanted to give some background here. Matt is our subject matter expert on this and was involved with the first iteration last session of writing this legislation, or the old legislation that was changed. Thank you.
I think actually I'll let Representative Sitek ask a question of the chief, and then we'll go to Matt.
You have no objection to the industry standard practice of giving away one drink at the bridal salon. It's the amended version, the selling, that you're objecting to.
We're going to remain neutral on this, and we're actually just going to leave ourselves open for questions. I don't want to make that sound like a cop-out, because that's not my personality. The way, the other thing that happens with giving the alcohol away, which really was a cutout, because you can't give away alcohol in our world other than the cutouts that have happened for the manufacturers. So as we move forward, we realize this. when you start selling alcohol, you start breaching into what we do as a daily basis. And I would only correct Chairman Hunt because his committee keeps making license types on us. We're substantially over the 38. We were brought in to shrink that number down, and we're going in the wrong direction on it because of cutouts. This one, nobody is going to give away alcohol in excess because it's not, in the world of business, it's not conducive to creating the environment that was stated here. So that was Chairman Hunt, historically, last session, that was Chairman Hunt's reason for doing the free alcohol restricted to what it was. Just because the second deterrent in that, if you will, it was costing money for that free alcohol to go out the door, and there wouldn't be an excess of that being given away.
Follow up?
If you were to take a position on the question I asked, would that possibly be yes?
So if I could just reiterate, the question was the way the bill is written now. Yeah. So we're about parity and fairness. And like CJ had stated, and Mike had stated also, we're in the middle of the parity being, the lines of parity being blurred a little bit. And that isn't blurring the tiers, whole different subject. That's blurring the fairness. And I see what they're saying. The industry spoke very loud when I came in the door. And I will tell you, through the trials and tribulations of running a regulatory business, industry has always, at every level, has always come to bat for us, because at the end of the day, the structure that we had built under this new, I keep calling it a new liquor enforcement, but it's almost 10 years old. Under this new model, we strive for fairness, and we strive for doing the work professionally and literally equitably. So, did I skate your question again, Representative?
I heard you.
Okay, thank you. Sorry about that.
I'm thinking we probably should have both of them speak for us to ask the questions, if that works. Thank you.
Thank you, Madam Chair and committee members. Lieutenant Matthew Culver, New Hampshire State Liquor Commission, Division of Enforcement and Licensing. There has been quite a bit of discussion on the importance of food. And since prohibitions in the state of New Hampshire with our three-tier system, food has always been paired, generally speaking, with all of our license types. The reason food is paired is because it does slow down our metabolism. Alcohol is generally consumed through the mouth and goes into your stomach. When it passes from your stomach into your small intestine, it goes through the pyloric valve. It's a valve called the pyloric valve. When it's in your small intestine, 80% of the alcohol in your system, that's where 80% of the alcohol is absorbed into your system. Then it's flushed out through your kidneys and in liver at a rate of 0.01% per hour. Okay, so when the alcohol is sitting in your stomach, if only alcohol is in your stomach, the only thing that you've eaten or drank is alcohol, your stomach doesn't feel that it's full. The pyloric valve only opens when your stomach feels that it's full. That's why I'm sure all of you have seen it before, if you consume 4 or 5 shots, you don't show any signs of intoxication at first. Until your stomach feels full, the pyloric valve opens, contents of your stomach dump into your small intestine, and 80% of that alcohol is absorbed into your system. That's why a person can go from, I don't see any signs of intoxication, to falling off the bar stool in the matter of a few minutes. Okay, food slows that process down. Carbonation slows that process down. It tricks your stomach or your pyloric valve into opening more frequently, dumping the contents of your stomach into your small intestine, and it's absorbed over time, not just all at once. So that's the quick anatomy physiology lesson on the importance of food that has been paired with most all of our licenses. This amendment to the bill simply changes only two significant things. It breaks it down into the two tiers, right? So existing law, you can already give the one drink per customer away. Like the chief said, we worked with the industry members in creating a solution for them last legislative session in order to be able to do what their industry was doing at the time, giving a drink away, a simple drink away, while they were getting services rendered from a salon or barbershop. And now the one session later, it's breaking out into the tiers, which you've heard the testimony that it is causing disparity amongst our licenses. As the chief discussed, we do have more than the 34 licenses. We're up to almost 56. The only license that we have that does not pair food directly with the service of and consumption of alcohol is our cocktail lounge licenses, which you've also heard. Those licenses are $1,200, not the $1,280 that was incorrectly stated. But I wanted to clear that up for you as well.
Thank you. Representative Slotchie and then Representative Thiebaud. Sorry. Okay. The Representative Thiebaud.
Thank you, Madam Chair, and thank you for taking my question. This is for either of you, if you can answer. Do we have businesses like cigar bars in New Hampshire? And if so, are they also required to carry food?
We do have the cigar bar license. It's covered under 17821. And whenever, and thank you for your question, by the way, but whenever we have a unique license, such as a cigar bar, there's many more restrictions on those licenses than there would be on, say, a restaurant that is directly paired with food, right? So that's why you heard the billiards, the testimony on the billiards. Well, it's 12 non-coin operated billiards machines that you have to have in that establishment in order to qualify for that license. Cigar bars is a good example. They specifically in that statute, they are prohibited from having food because largely in part, I believe it's because of the Indoor Smoking Act that they're smoking inside the establishment. Another good example would be like a social club. A social club, it falls under our cocktail lounge licenses. However, they don't have a food requirement. But what they do have is they only can allow 4 members or 4 guests per member. They all have to sign in. It's a private club. There has to be a buzzer on the door to allow the members in. So there's a lot of other restrictions when you don't have food. Thank you.
Can I follow up, Madam Chair? Can
Yes.
I follow up on that? And thank you, as Matt said, thank you for your question, Representative, because it brings up another point, and that is if you had a license type that you have a lot of problems with, what is that license type? You mentioned it. And for the reasons that we're talking about today, they're very work intensive to have oversight of, to make sure that people are safe. And I would even commit to saying that publicly, some of the egregious events that you hear about in the news have happened in correlation with some of those establishments. So when we talk about cigar bars, which that license type was made for a cigar establishment to have a drink with, not to become a nightclub. So, which is where they went. Unintended consequence, right? Nobody knew that they were making it before my time. Nobody knew that they were making that license type to create what they did. Nobody wanted anybody to get hurt, but people started getting hurt. And they were residents of our state that every one of us here represent. So it pulled on our heartstrings. We've reeled it back in through partnerships, through collaborations. But as you all know, local municipal law enforcement is strained right now, just like we are, just like my old agency was or is. So everybody stays in their lane, and our lane is liquor and tobacco enforcement. So we see this often, and we get referrals from municipal police departments often on this exact. Good question. I like the way that you brought it up because it sticks in our hearts pretty hard, heavily. So thank you.
one more thing to add to that, Representative. The cigar bars also have a 60-40 split on their alcohol. So 60% of their items have to be non-alcohol, 40% can be alcohol. So it's much like the 50-50 split for full-service restaurants until you hit the $75,000 mark, and then you're exempt from the 50-50 requirement.
Representative Pearson and then Representative DeVries.
Thank you, Madam Chair. I have two questions. The first one's we'll call the first one easy. Liquor liability insurance, is that required as part of the licensing process in New Hampshire?
Thank you, Representative. It is not required in New Hampshire. If a licensee were to go through an adjudicative process, an administrative adjudicative process through us for typically a serious violation, then that could be a settlement agreement situation where they.
Like an SR-22?
I was going to use that example.
Yeah, exactly.
Okay.
Yep. But it is not required to obtain a license.
Gotcha. Follow up for my second one?
Follow up, yes.
The other one, we heard testimony about increased revenue to the state. We'd have all this money coming in.
Sorry.
But in reality, this coin has a second side. So now we're looking at, can you talk about the enforcement costs and side of this? Because it's not just simply money coming in. You guys have a role in the other side of the coin. Can you talk about what that would look like?
Certainly. Do you want me to take that? I can take it. So currently we have 7 active licenses, barbershop licenses and salons, and 17 pending. Now keep in mind, this was just passed last legislative session. So it is a growing industry. So right now you're looking at the potential of 24 licensees. We do inspect all of our licensees before they're issued a license, and we do do inspections throughout the year. Our sworn investigators will inspect these locations. Now, it is also important to know that, we can't predict the future, but history has a tendency to repeat itself. And when we're looking at, the cigar bar came up, nobody at that time anticipated the amount of enforcement efforts that were going into that specific license type. And there is a possibility that violations could increase out of this license type and would have to be examined by our investigators. So it's hard to say to pinpoint an exact amount on that, but there is a potential that could happen.
And just to add to that, Madam Chair, if I can just add to that.
Yes.
Representative, also just coming off of what Matt just said, one thing that what we're trying to instill in everybody, not only here, but the public, is the paradigm shift that has happened with this organization is we're embracing the partnership between us and small business. We get it. And we're trying to help them, whether it's just applying for licenses and our investigators going out and sitting down with the licensee and actually typing out their license for them, or working through legislation such as this. This initial bill that became law was done in partnership. We sat down with industry. We actually sat down with OPLC also, because they're the holder of the professional licensure, and recognized how we could do this safely, and help the industry do what they want to do. And when we came to this iteration of this bill, again, like I spoke about earlier, we weren't brought into the fold on this. So it was really tough for us to wrap our heads around. We're bringing you into compliance so you don't commit felonies, and now this is another money-making proposition that is going to have possibly some negative stuff attached to it if we don't implement our training. We have 715 now training platforms that we do with service, with management, with door people, our own stores, kids. It goes on where we're always on site making sure that the service of alcohol is done responsibly. And great choices are being made in the consumption world. And we just were really nervous that this could go awry at the end of the day, because the sale of the alcohol shows that this is something that is going to be pushed, marketing wise, is going to be pushed forward, possibly aggressively, and create an unintended consequence on the backside. Could that happen? I guess it's a coulda, woulda, shoulda. I just don't want to be back in front of you or criminal justice or commerce talking about the negative incidents, bringing victims in and talking about the negative incidents that came out of legislation that had already been placed forward and actually vetted out pretty thoroughly. And I'm not saying that the legislators involved in this didn't vet this out thoroughly, but we weren't involved in it.
Representative DeVries.
Thank you, Madam Chair. This is new to me. I just want to make sure that I'm fully understanding it. If you're a bar, you have one of these cocktail licenses or restaurant licenses, after 9 o'clock, you're not required to serve food. Is that correct?
Thank you, Representative. For our restaurants alone, there's 3 different groupings. The first is the beer and wine license, where there's a limited food requirement on that. It's for your standard pizza places. It's counter service. You order a pizza at the counter. You order a beer with your pizza. It's delivered over the counter. Top is removed. You go back to your seat. When you add liquor to that, the standards increase on it, or the restrictions increase. Now it's considered a full service restaurant. You have to meet certain definitions. That is one of them. Full service restaurant, serving full course meals. You have to have table service. It is what you traditionally would think of as a restaurant. The third is the cocktail lounges, which restaurant is a piece of that. On a cocktail lounge restaurant license, you have to meet the requirements of a full service restaurant. However, you can close your kitchen at 9 p.m. and continue serving alcohol without the benefit of food.
Thank you. May I?
One follow-up.
Thank you. So to make sure that that was really lovely overview, as was your biology lesson on the pyloric valve. But my question, I suppose then, somebody could come into one of those cocktail restaurants. There's no requirement that an individual person eat food when they go into one of these establishments and start drinking. I'm trying to make sure that I understand, because I understand that the salons and the barbershops would not be serving food, but there's no requirement that when I take a shot of tequila or 2, because I'm from Hampton, I wonder whether or not that it happens a lot. So we have these problems down. You may be aware. I bet you are. My question is, but there's no requirement that other people eat food when they're drinking, right?
That's correct, and thanks for the follow-up on that. That's where the 50-50 requirement would apply to the restaurants, right? So you have that 50-50 split. If you're not serving or promoting, advertising, encouraging people to consume food, you're not going to meet that requirement. You're not, and we've seen this in the industry, right? We've seen establishments open up with a very limited menu, barely making the definition requirements, but still making them. And we immediately start educating on the 50-50 requirement. So if you're only serving hot dogs and popcorn, there is no way you're going to get to your 75,000 exemption, and you're not going to meet your 50-50 requirement. So what will happen in that circumstance is you will be reduced to a lower level license. You'll go from the beer, wine, liquor license to the beer, wine, where there is no 50/50 requirement or $75,000 exemption. You're welcome.
Thank you. Hold on. You just figured that out. Representative Schmidt for a question.
Thank you. So, but you can't serve somebody who is visibly intoxicated, no matter what your situation is, correct?
That's correct.
So you come in and you're not ordering food, but you're going to get booze. They've got servers have got a responsibility not to serve you if you're getting into a situation, even if you haven't started to tilt off the chair yet.
So, can I? Sure.
You can answer.
Yes, Representative, and thank you for your question. Now, to morph the two questions together here, outward signs of intoxication are exactly what we train on a daily basis. And we are in your backyard, down at the beach, coming up here very shortly at the big establishments, not to mention them by name, but the large establishments on the beach. But that shows you how responsible they are. And they want the training. And one of the venues, which is extremely large, actually calls everybody to come into their venue, all the other servers on the beach, to actually sit down and hear us, because not only are we giving you what Mike will talk about time and time again, tips training, we don't get into tips, we get into state law. That's all we care about in responsible service. For these establishments to go through tips training is great. I wouldn't shun away from any training, but we will talk about actually what all of you pass legislation on a yearly basis. We actually educate our licensees on it in person, especially in your backyard. And if you'd like to join us, we'd love to have you along. But that we are so proactive in a law enforcement. I've been in law enforcement for 39 years now. Law enforcement tends to be reactive at times, unless we're doing speed enforcement. And those times usually have negative connotations attached to it. We're in these people are in a very risky business, and we have oversight of it. And we just want the laws that all of you pass to actually be implemented the way they should be, the way you intended them to be. At the same time, we want to make sure that there are no regrets at the end of the day that something is not done right, and the decisions that are made here or back over on Capitol, on the Capitol campus that are made over there aren't done in a way that everybody isn't educated on the decisions that they're making and the changes that they're making also.
Thank you very much.
Thank you for the opportunity.
Yes.
Sorry.
Thank you. Seeing no further questions, thank you very much for all of that information. I appreciate that. I assume that there's nobody else here to speak on Senate Bill 669. Seeing none, I will close that hearing. We did just work through lunch. I know a few of us do need a quick bio break. So Senator Rochford, I hope you don't mind. I know you're here for the next 3. I'm going to recess us for 5 minutes just to start 5 minutes late so that we are able to listen when you introduce your bill. I would like to open the hearing on Senate Bill 567 and welcome up the prime sponsor, Senator Rochford.
Thank you, Madam Chair, members of the committee. For the record, my name is David Rochford. I represent Senate District 1, and I'm here to introduce my bill, Senate Bill 567, which deals with the composition of the Board of Dental Examiners. Very straightforward. I learned by now not to say it's a simple bill, but I think it's a simple bill. The background of this, really, just to be clear, I got a call this summer from a member of the Board of Dental Examiners, and this isn't an official request by the board. It's not an official request by OPLC, but he shared with me the fact that they're kind of in a conundrum right now in that every member of the Board of Dental Examiners is a specialist dentist. So there's no general dentist on the Board of Dental Examiners. And which he ran into a problem, explained to me, like, we had an issue, we didn't even know how to answer the question because we're all specialists. So the question came up is, can we add one member or can we change the composition of the Board of Dentistry? And I said, why don't we just designate one member of the Board of Dentistry has to be a general dentist. This would make sure that most of their issues are addressed by having a member of the general dentist. They wouldn't have to pause hearings or recess hearings to bring in a specialist. And that's all it does, is it designates that one member is a general dentist. We put the effective date based on, we looked at the current composition of the board, and it looks like the next dentist to cycle off the board will be in September. So we put this to be effective in September of 2026, and that's all there is to it. And this is not unorthodox. You know, as a pharmacist and as someone who has been on the board of pharmacy, about 20 years ago, the Board of Pharmacy was in the same situation, wherein every pharmacist on the board, through no fault of the board, no fault of the governors at the time, was a community pharmacist. So now the Board of Dentistry, Board of Pharmacy has a specific member that is a member that represents hospitals. So it's not it's not unorthodox. It will ensure that there's variety on the board and ensure that some of the most common, most basic issues affecting dentistry and the issues that affect that are represented by a general dentist. So that's the bill. I'm happy to answer any questions if you have any.
Thank you. My first question is, with the Board of Pharmacists, was that changed through changing the statute and the board composition?
It was, yes.
Okay, thank you. Representative Sytek?
Senator, isn't every specialist start out as a general dentist? I mean, what?
Yes and no. Dentists graduate with a dental degree, and much like medicine, they'll choose to go into a residency and then to specialize from there. So, for instance, you know, my brother's a dentist. He did not ask me to do this bill, but he is a dentist. He's a general dentist, but his colleagues and friends, some of them went directly from dental school into oral surgery. Some of them went directly from dental school into orthodontics or oral surgery. So, yeah, there is a fair amount. They all have a basic groundwork of education, but where they go after graduation day can vary differently. Yep.
Thank you. So you would say that it would be important to have a dentist who sees a broad cross-section of dental practice as useful.
Absolutely. And I'm going to rely on my own experience on a former Board of Pharmacy member, whereas if we were completely one homogeneous subset of professionals, we just wouldn't have the input, the background, the perspective that adding other members on would.
Fantastic. Thank you. Are there other questions from committee members? Seeing none, thank you very much, Senator.
All right. Thank you.
Does anybody have any questions for the Executive Director of OPLC on this bill? Because she is here for questions if needed. Seeing none, with that, we can close the hearing. I will need a pink card from you, Senator, and I will need one for the next bill as well, although you can fill those out for us after you are doing this. So the hearing on Senate Bill 567 is closed. And I will open the hearing on Senate Bill 425. And once he's ready, I will ask Senator Rochford up to introduce this bill as well.
Thank you,
And if
Madam Chair,
would
members
you-
of the committee.
Sorry, Senator, would you mind just laying down the now hearing
Oh,
since that
yes.
one is not accurate?
Can we change that for you?
You could change it or you could just set it down for us, whichever you prefer. We're into 425 now. We did not change that for your last bill.
All right.
If you just leave it laying down, that
All right,
works.
sounds good.
Thank you.
Very good. All right. For the record, my name is David Rochefort, represent Senate District 1. I'm here to introduce Senate Bill 425. And obviously, I'm not the prime sponsor on it, but I did a replace all amendment on this bill. I told the prime sponsor that I'd come and talk about this. This bill would actually have New Hampshire join a multi-state physician associate licensure compact. Now, I want to speak about the merits of the PA compact, and I'll touch on why this bill wasn't introduced as a regular bill. As I said, this came over as a replace all amendment. So Senate Bill 425 would have PAs join other healthcare providers who enjoy the benefits of a multi-state licensure compact, including physicians, nurses, psychologists, physical therapists, I think speech therapists have it, maybe occupational therapists and other counselors. So it's not uncommon for the state of New Hampshire. And Mr. Bartlett from the American Academy of PAs and Mr. Hathaway from the New Hampshire PAs are going to come and testify, and they're going to be answering some specifics on the bill. So if you have specifics, I would ask you to ask them. And they'll testify on how the compact is formulated, how it's structured, and what the benefits are, not only to PAs, but to New Hampshire in general. But I do want to make a few points before they come up. This bill continues the efforts by the legislature, the governor, and OPLC to streamline the licensure process in New Hampshire, something that we've all been talking about for a number of years, without compromising safety. And more important, this is really a healthcare workforce bill, and I'll get into that in a little bit. And I think there's some other folks from HHS that may be able to talk to that as well. But what this will do for PAs is what physicians and nurses and nurse practitioners enjoy, which is allow PAs to more easily practice in more than one state, which is important given how close we are to our neighbors. In fact, I just gave a speech over at the University of New England, who has a PA school. They're really looking at New Hampshire as a leader in this field, in this profession. They look at not only our licensure, the abilities to practice under the licensure. They look at the quality of life in New Hampshire. They look at our low taxes in New Hampshire. So there's a desire to bring some of those providers, new grads over from Maine into New Hampshire. And Maine is one of the 24 states who have joined the compact, and Massachusetts is moving towards that probably by the end of the year. This bill will make New Hampshire more attractive to PAs, as I just mentioned, and it will allow us to bring qualified healthcare providers into the state, which I can tell you, where I live is a real concern up north. But one of the things I want to tell you it will not do, it doesn't change the scope of practice. That's not what it does. Only the legislature and the Board of Medicine can change the scope of practice for PAs, and this bill will not do that. The PAs would be required to follow all applicable laws and regulations governing their practice in our state. And moreover, this compact does not allow one state to dictate how another state practices. And I think that's important. I think as New Hampshire, live free or die state, we don't want to be told by Maine or Massachusetts how to run our business up here. And this bill will not do that. It preserves states' rights, and will allow to really, look at where I come from. I'm right on the I'm at the skinniest part of the state. So I've got Maine on one side of me, a couple miles away. I've got New Hampshire or Vermont literally on the border, and this would allow, in my summation, some cross-pollination of practitioners. That would allow hospitals and providers to utilize professionals that may be licensed in one state and go over state lines. But I do want to explain why this isn't what you'd see as a normal compact bill. And it's important that the language in this is preserved to and I know, I mean, everyone kind of wants to protect their turf, right? And I don't really want to say that this is a Senate bill, this is the way it should be, but this is the way it should be because there's bigger things at stake here. And it goes into the Rural Health Transformation Grant. So when the federal government set forth its scoring criteria for the Rural Health Transformation Program, it gave added scoring weights for states in the PA Compact or with legislation that's pending. And we have legislation, this is obviously part of that. In its Rural Health Transformation proposal, New Hampshire committed to taking steps to join the compact. So with the blessing of the governor's office and DHHS, who's behind me, that's why I put this. That's why I put this bill forward. And I do want to note, it's important to note that New Hampshire received $204 million with that grant, and the key components of that grant, we're looking at states who have a large rural population who are willing to make transformational changes to the way they do healthcare. We got $204 million. We got more than any other state in New England because I think New Hampshire not only looking for in the past what we've done on these things, also looking at the forward, we really fit the model that they were looking for as they were trying to fill out these grants. I know in the past I've spent time in the House. I'm in the Senate now. I know there's been some consternation about compacts, and you know I think it's important to understand that this one was not taken lightly. When I was approached to do this legislation, I said, hey, these compacts have not always fared well in the legislature, but understanding that this is a piece of a bigger issue, I decided to bring the bill forward. So, it is important to the funding of rural health. It's important to access to primary care, especially in our rural communities. So I'm going to give the bill to you now, and I'm happy to answer any questions. But like I said, there are people from the PA community as well as the department that could probably get into some of the more specifics of the bill.
Thank you very much. One question I have for you, Senator, is this compact would say that somebody has no felony or misdemeanor conviction. And as far as I'm aware, I believe we do have some flexibility for evaluating and seeing if that's something that would impact people's ability to practice.
Yeah, that might be a question. I know OPLC is here as well. They might be able to comment on that.
Okay, thank you. I was just worried about that on the workforce. I will save that for them. Are there any other questions? Seeing none, thank you very much, and we'll let you get back to your other committee business.
All right.
Thank you. Next, I will call up, it looks like both Michael Bartlett and Michael Hathaway want to be up together at the same time. If not, we'll have one of you come forward first, but it looks like with your cards, you wanted to be together. So we'll have each of you introduce yourself with the microphone with the light on, which means that it's good, and then we can hear your testimony.
All right. I'm Michael Bartlett. Thank you, Chair Leon and members of the committee.
Sorry, could you also state who you're representing?
Yep. So I'm Michael Bartlett. I work as a manager of state advocacy and outreach at the American Academy of PAs. We are the national organization that represents the 190,000 PAs or physician associates working across the United States. And so I'm here today to speak in support of SB 425, which would enact the PA Compact. This compact, it's an interstate occupational licensure compact for PAs that will facilitate interstate practice. It's similar in form and in function to many of the other compacts that have been enacted by New Hampshire, such as the Interstate Medical Licensure Compact, the Nurse Licensure Compact, Physical Therapy Compact, the EMS Compact, and the Occupational Therapy Compact. This PA Compact has been enacted in 24 other states, including Maine and Connecticut, and it is also under consideration in 10 additional states this legislative session, including Massachusetts and Rhode Island. The PA Compact utilizes a mutual recognition model of interstate practice, where compact members agree to recognize valid licenses issued by other member states. And to use the compact, a PA must have a license in good standing in any state participating in the compact. When a licensee wants to work in another member state, which is known as the remote state, they will obtain a compact privilege from the PA Compact Commission, which is the interstate body that administers the compact. This compact has many benefits for New Hampshire PAs. It facilitates multi-state practice by reducing the burden of maintaining multiple licenses. It expands employment opportunities for PAs by authorizing practice in other member states and allowing practice in new markets. It improves continuity of care when patients or providers have to relocate, and it also supports military spouses who have to move from state to state frequently. And the compact also has several benefits for state regulators. It reduces application processing time, encourages cooperation among member states in regulating PA practice, and facilitates board cooperation on investigations and disputes. It enhances public safety through a shared data system. It allows states to charge a fee for a compact privilege as well as for renewal. And it also preserves the current state-based licensure system. Adopting the PA Compact will also increase the federal funding that New Hampshire receives through the Rural Health Transformation Program. In its application, New Hampshire committed to joining the PA Compact as part of its strategy to strengthen and transform rural healthcare. So fulfilling this commitment will improve PA mobility into rural and underserved areas, making it easier for New Hampshire to recruit and retain providers where they're needed most. And it's important to note that the PA Compact does not affect scope of practice. PAs practicing under the compact must abide by the laws and regulations of the state where they are practicing. So PAs in New Hampshire using a compact privilege will be required to practice under the laws and regulations of New Hampshire, just as PAs holding a New Hampshire license must do today under the traditional licensure model. The PA Compact simply streamlines the process for PAs to obtain authorization to practice in other member states without the need to apply separately through each state's licensure application process. And we recognize that New Hampshire has taken efforts to improve the process for individuals licensed in other states to get licensed in New Hampshire by enacting reciprocity legislation. While both reciprocity and licensure compacts improve professional mobility, they do differ a bit in scope and structure. Compacts create a formal, uniform, and interstate agreement that allows specific professions to practice across member states, while reciprocity often only allows a single state to independently recognize another state's license. And the PA Compact also allows states to share disciplinary data through a centralized data system, and this allows state boards to instantly check the disciplinary status of a practitioner. And it's also important to note that the PA Compact is totally optional for PAs and that it can work alongside the current system of state licensure and New Hampshire's reciprocity laws. Overall, the PA Compact will improve access to care and continuity of care for New Hampshire patients. It will increase licensure portability for PAs and support military families while maintaining the current system of state-based licensure. Thank you for your time and consideration. I'm happy to answer any questions.
Thank you. Representative Grota?
Thank you. How many states have adopted this compact?
24.
Follow up.
So in the compact, in what you said and what Senator Rocha said was that New Hampshire PAs would have to follow the licensing requirements of New Hampshire.
Mm-hmm.
So if we were to have how do we know that a PA is coming from another district or another state has the qualifications to meet the requirements for New Hampshire? So, because in a true compact, right, there's mobility between states without any question. But in this compact, you don't have that. So how's that facilitated?
So in order to become a PA, you have to go to PA school and graduate with a degree and then pass a national certification exam. I believe that's standard across all 50 states. And so that PAs who want to participate in the compact have to have a PA license. And in order to get a PA license, you have to go through that education. You have to pass that certification exam. You have a certain number of hours of patient care experience. And that's uniform across all PAs in all 50 states.
Follow up.
And so are you telling me that the hours that you work, the supervision hours are the same throughout the states?
So in certain states, PAs, the hour requirements differ. So in certain states, PAs don't have to be supervised by a physician at all. In other states, it's after a certain number of hours of patient care experience. In other states, all PAs have to be supervised at all times. But all PAs in every state have that foundation where they have to have a bachelor's degree, they have to have a master's degree, and then they have to pass a national certifying exam. And during PA school, they have to complete a certain number, standard hours of patient care experience. And Malcolm here is actually a PA, so he can speak to some of those qualifications. I'm not a PA myself, but I do work for the national organization.
You can have one more follow-up.
I'm going to take another stab at this because I don't feel like my question was answered. Are you saying that the requirements for this compact are the lowest common denominator between each state, or how is it that a PA, let's say in Ohio, that has no supervision hours required, then can come to New Hampshire where we do have supervision hours? How is that going to get washed in this compact agreement?
So what's important, I think, to note is that the compact, you can only join the PA licensure compact if you are a fully licensed and credentialed PA. And in order to do that, you have to go to PA school, get your degree, complete a certain number, I believe, is it 2,000 hours? It's usually standard during PA school of patient care experience. So just in order to get your PA degree, you need 2,000 hours of patient care experience, and then you take a national certifying exam. So that's the standard, just in order to get licensed as a PA and credentialed as a PA in any state.
Thank you. Representative Sitek and then Representative Sellers.
I'd like to follow up on Representative Grota's line of questioning. Is there a significant difference in PA scope of practice throughout the states? Are they pretty much I'm looking to hear that they're pretty much the same, or are there significant differences?
So PA scope of practice does differ in, in different regions and in different states. But the important thing about this compact is that PAs have to follow the scope of practice, the laws and regulations of the state that they are in. So you can have a PA coming from another state with a different scope of practice, but when they come to New Hampshire, they have to follow New Hampshire's laws and rules.
Thank you. Representative, that was answered. Are there any other questions? Representative Schmidt?
Thank you, Madam Chair. So when they come from this other state, and Representative Grota gave the hypothetical question of coming from Ohio, where we are positing that they don't have the same requirements as New Hampshire does. The fact that they're required to adhere to the New Hampshire standards doesn't tell me how they're going to know what the differences are when they arrive here with that compact blessing, but they don't know what we require that they don't learn in Ohio, hypothetically.
Well, PA education is uniform across all 50 states. So when you graduate as a PA in New Hampshire, you have the same, you go through the same rigorous education, you get the same degree, and you have the same number of patient care hours as you do as a PA who graduates and gets their license in Ohio, for example.
Follow up. So, but how do they, if they get the exam, the education over there, it's uniform nationally, but New Hampshire has different requirements than hypothetically Ohio does. How does that PA, when he or she gets here, how do they know what they don't know effectively, or what they are not required to do there that they are required to do here? Because your answer didn't answer that question.
Yeah, so when a PA does come to New Hampshire, they will be reviewing New Hampshire state laws and regulations. So if New Hampshire requires them to collaborate with the physician, they will be doing that in New Hampshire, even if that's not the rule in the state that they're coming from. So when they move into a new state, they will know the laws and rules and requirements, and they will look at those ahead of time, and then they will base their practice off of that environment.
Thank you. I'm sorry, Representative Pearson, as long as it's not the same question for the 5th time.
I hope not.
Yes.
Okay, so normally, thank you for taking my question. I've been involved in this committee for a long time, and I've seen a lot of different compacts. I've also seen us withdraw from a compact that was not functioning. This compact sounds a little unique to me, because typically with the compact, what happens is they create, typically it's a board. Usually you get some advantages for being in early, right? Executive level. But then the compact establishes what those rules are, and then the states agree to follow that. But what I'm hearing from you, and please correct me if I'm wrong, is that is not the case in this. This is, I don't even know if I would call this a compact then, because if you're going to transfer from another state, and the requirements of that state are in essence irrelevant because you have to conform to what New Hampshire is requiring, why have a compact at all? Because it doesn't function like a normal compact, and it just seems to me that you just need to be transferred, go through the process of the blessing, and then you're up and running. Why would we have to go through a compact process that doesn't even look like an actual compact?
So I believe that the purpose of the compact is to lessen, how it works in the PA compact. Compact states agree to recognize valid licenses issued by member states. I think what the purpose is it lessens that application processing time, where normally if you have a PA moving from another state, when they come to New Hampshire, they'd have to send in an application, wait a certain amount of time. With the backlog, it can sometimes take a little while to get licensed. But with the PA compact, we do have a commission that runs the PA compact. It's called the PA Compact Commission. And so when a PA wants to move from another state to New Hampshire, they'd send a request to the PA Compact Commission, and the PA Compact Commission will grant them a compact privilege to practice in New Hampshire. So it's quicker than the ordinary licensure process.
Yes, if it might be the same one I wanted.
Thank you, Madam Chair. That is highly unusual, in the sense that an organization that is outside of the confines of the laws of the state of New Hampshire is granting a license to someone to practice in this state. That's really
So
unusual.
it's
So,
not-
unless I misheard your explanation.
No, sorry, it's not a license. It's just a compact privilege. And so New Hampshire, by joining the compact, would have a seat on that PA Compact Commission. So that writes the rules, the regulations that governs, the Compact Commission. So you have a chance to participate in that. But the important thing to note is that PA Compact Commission is not setting, okay, here's how you're going to practice in X state or Y state. You can get a compact privilege to practice in New Hampshire because New Hampshire is a compact member, but you will still be required to follow all the laws and regulations and scope of practice of New Hampshire, just as if you were a normal New Hampshire PA.
With the blessing of the commission and not OPLC or the governing body of the state of New Hampshire?
Well, I think by joining the compact, New Hampshire would have a seat at the table. They'd be part of that PA Compact Commission.
Do you know what the turnaround time frame for somebody applying for compact,
Yeah.
the right to practice underneath the compact would be through this system?
I do not, because at the moment, the PA Compact is still currently being operationalized, and it will be active in early 2027. So right now they are still putting together the rules and regulations and the guidelines, and they are setting up their database for the different providers. And so I do not have an estimate of the amount of time it would take to get a compact privilege, because they are still working on operationalizing it.
Thank you, Representative Grota, and then Representative Sellers.
So typically, when a compact is organized, there is a group of individuals that there's a target number. Like we're going to start the rulemaking when we have 15 members to the compact.
Yes.
Has that been reached with this compact?
Yes, that was reached, I believe, in 2024. I think when 7 states joined the compact, then they began operationalizing it. And so they're in the finishing stages of that, and we expect it to be ready by early 2027.
So you're telling me that after 7, so you have 24 members now. So it's taken almost 3 years to write the rules for this compact?
Well, they also had to find a database and do some other work as well to get a interstate compact up and running. I don't think it's a small and quick process.
Representative Sellers?
Yeah, thank you, Madam Chair. So let me make sure I'm getting this because I think I do. The compact, if Ohio, you have your national certification, good in all 50 states. But now Ohio says, hey, you need an extra 1,000 hours and practice. In New Hampshire, now you go into New Hampshire, and New Hampshire just says, well, you need 1,200. Are you saying they got to go and make up the 200 if that's what they're doing?
So, yes, in order to practice in New Hampshire, you'd have to meet that hour requirement.
Thank you. And we probably would like to hear from Mr. Hathaway as well. Thank you.
Good afternoon, members of the committee. For the record, I'm Malcolm Hathaway. I'm a president of New Hampshire Society of Physician Associates, NISPA for short. I'm a resident of Exeter, work in Portsmouth, and I'm here in my personal capacity as well as president of the NISPA. You may recall that NISPA represents over 1,100 PAs in the state, as well as the students that attend the 2 PA programs in New Hampshire, Mass College of Pharmacy and Health Sciences in Manchester, and the Franklin Pierce PA program in Lebanon. Senator Rochefort and Mr. Bartlett here did a lot of the substance here, so I just want to emphasize a few important notes here. First, even though New Hampshire has licensing reciprocity, PAs still have to go through the regular licensure process when moving to the state, or otherwise taking a job in New Hampshire if not already ever been licensed here. In other words, as has been mentioned, I think that their streamlining is really the side that we look at as being helpful. While that does not mean that PAs in the state don't have to go through the regular license process. Second, the compact is very strong in preserving the rights of the states participating in the compact, which Senator Rochefort already spoke of. And third, this compact improves patient safety as enforcement actions are immediately known. This was already mentioned to all the participating states. And so when states are linked in, it's if there's a grievance or something, whatever that might be brought, it's just more transparent and better known. As we've seen in the past, there's been times when providers, this has happened, and this will help ease that as well. So again, this is on the administrative side, and there's been times we have had not only with PAs trying to obtain licensure, but also even renewing. We've seen a lot of backup in administration, and so this will help ease that as well, for sure. And thanks for your time, Madam Chair, and I'm happy to answer questions.
Thank you very much. Are there questions from the committee? Representative Duray? Oh, sorry, we should have asked the questions after both of you had spoken, so you'd have a chance to answer some of them as well.
That's okay.
Seeing none, thank you very much. And next I'll call up Patricia Tilley and David Chorney from the department.
Good afternoon, Chair. Thank you so much for allowing us to speak this afternoon. My name is Patricia Tilley. I'm an Associate Commissioner at the Department of Health and Human Services, and with me,
David Chorney, the Director of Financial Sustainability and Policy for the Governor's Office of New Opportunities and Rural Transformational Health, or Go North for short, which is lead on executing the Rural Health Transformation Initiative.
Great. And so we're here together between the two, both the governor's office and the Department of Health and Human Services, to support this bill. From the department, we've already heard much of the technical pieces of that from your previous folks who've come up here. We're happy to answer any of those questions, but I'll just skip forward to why the department feels like this is a really good idea right now. So from a DHHS workforce perspective, thinking about the healthcare workforce, it expands access to care, especially in rural New Hampshire. Our New Hampshire DHHS Health Profession Survey suggests that primary care practice concentrations are significantly smaller in rural regions. We probably can get that intuitively, with Sullivan County facing some of the biggest shortages. So enabling multi-state PA compacts or mobility will help fill those gaps more quickly. We believe that it will streamline compact privileges. I know we just had a robust conversation around how that will or will not. We would suggest perhaps OPLC can sort of walk through some of those technicalities. I don't want to take the thunder away from what they understand. But what we're really interested in is that it provides increased opportunities for telehealth with providers from other states as well. So it really increases opportunities in those rural areas to get the sort of primary care that you need. We know that it aligns with New Hampshire's workforce trends and pipeline realities. So we know that PAs are a critical part of New Hampshire's healthcare workforce. Our data suggests that the PA workforce is growing. It grew about 15% with higher rates of newly trained providers in rural areas. Again, this is really a wonderful way to augment the kind of healthcare that we get in rural communities. Number 3 for our support is it speeds recruitment and retention into shortage areas. So I think we, again, heard some of that conversation early on, that the intention for a compact is to speed through some of that red tape while still maintaining states' ownership of the process, that any of those folks are going to have to meet New Hampshire laws and regulations, all of the requirements that you were just talking about. And then similarly, that preserves state authority and patient protection, all while enhancing some of the mobility. But number 5 is really the most important thing, and the reason why David and I are sitting here together is that joining is strategically aligned with our CMS Rural Transformation Grant. New Hampshire, as you've heard from Senator Rochefort, has been awarded $204 million for 1 year of a 5-year grant. We brag all the time that was the highest amount in New England, and really at a national level, New Hampshire is being looked to as a leader in this area. And David's going to speak more directly to this, but by joining this PA compact, it directly improves New Hampshire's future grant competitiveness. It unlocks some discretionary funds tied to workforce policy, and it reflects so that we can show leadership in this area of sort of modernizing our workforce. So I'll hand it over to David.
Thanks. So in the Rural Health Transformation Grant, it's a grant from CMS. The administration laid out certain policy commitments states could commit to implementing. If a state committed to implementing that policy commitment when they submitted the grant to CMS, they were awarded extra points, and those extra points translate into additional grant dollars for the state. There are 3 categories of policy commitments that the administration put into the grant as a priority. One's around healthy lifestyles. The other's around scope of practice to make sure that providers are practicing at the top of their license. And the other is on streamlining licensure requirements to enable states to quickly get practicing providers into the state. What New Hampshire did, led by the governor's office, was committed to implementing the PA compact, just the streamlining of the licensure piece. There were no changes or commitments made to changing the scope of practice for physician assistants. And to really deal with what we see as an acute issue for access to primary care providers in a lot of rural New Hampshire. And the dollar amount that the commitment to the PA compact made was about $20 million. And the way it works in the CMS grant is the money was, if you committed to the policy, that money was provided in that first annual award. And then if states that committed to policies don't follow through and commit those policies, the federal legislation requires CMS to recalculate a state's award. So in future years, it'll impact funding. It'll decrease funding in future years. So that should say there's a, if New Hampshire, and the deadline for that is December 31st, 2027. So there's a financial commitment the state has made, or there's funds tied to the policy commitment to help with the workforce issues within the state's rural health transformation plan.
And so I think just to wrap that up, I think the notion of the PA Compact aligns with both DHHS and Go North. It offers a tangible way. It's a low-cost policy solution, quite frankly, that unlocks additional resources for the state, and hopefully, and we believe, it will really support access to primary care in those rural communities. So thank you very much.
Thank you. So my first question is sort of a two-part question for you. The first is, can we get a list of the rural health transformation grant commitments that were made with the specific policy positions? If you could email that to me, I just want to make sure that we're as competitive as possible. And then the second is just a clarification that what we heard is that we need to be making progress towards it. So as long as we have pending legislation, we are following through on that commitment from the governor's office for Go North.
Yes, but the pending legislation, at some point we have to implement. So the pending legislation has to go to enacted.
We need to continue as a follow-up. We need to continue working
Yes.
on the process in
Yes.
order to find something that does work for the people of New Hampshire.
That's in line with the physician assistant compact. And I'm happy, I'll just share, and then I'll also email the other policy commitments. So the state committed to implementing the presidential fitness program, and in line with guidance that'll be issued by the federal government, requiring nutrition as a continuing medical education requirement for licensure, joining the physician assistant compact, and also the EMS, the Emergency Medical Services Compact, expanding pharmacy scope of practice to allow for prescribing and the ordering of lab tests, legislation to help the independent billing of dental hygienists, and then implementing a Medicaid, Medicare dual special needs plan, which integrates sort of someone's Medicare benefit with their Medicaid benefit so that there's better care coordination for that population.
Thank you. And if you can email that as well. Thank you. Representative Pearson and then Representative DeRoy.
Thank you, Madam Chair. You just listed off a bunch of different compacts. Are those all, is that a one big basket? Is it all, we got to do all these? Because we just pulled out of an EMS compact 2 years ago because it was an absolute disaster. So I just want to make sure that this isn't an all or nothing, because if it's an all or nothing, you're going to get nothing.
It's not all or nothing. Those are all the policy commitments the state made, but they're not all bundled together. So each of them had 100 points, essentially. And so there was 100 points for the physician assistant compact. There's 100 points for the presidential fitness program. And so doing one and not the other doesn't put the whole program at risk, but it will impact.
All right.
It's really an a la carte menu. So as we go through, and there were other policies that the governor's office did not move forward because they were not aligned with where she was. So this is what we committed to. We're bringing it to the legislature. You've certainly, that sounds familiar to you on some of those other bills. And so that's what you're contemplating.
Thank you. Just before I get to Representative DeRoy, if we could get the full list of the menu that was offered to the governor. I know that we need to get to an agreement amongst everybody to implement these. So if we know the menu she chose from, that would be helpful.
Yep.
Thank you. Representative DeRoy.
Thank you, Chairwoman. It feels like a monopoly to me. Is this a monopoly? No? That all of these pieces are coming together as one, so that your the medical, the pharmaceutical, all of that. No, am I reading this the wrong way then?
Yeah, I think so. They're well, they some of them could potentially.
Actually, if I could try, I think it's more. I was looking at the full package from the Go North. And just trying to understand what all the different ones are, because we had heard some potential implementation challenges, especially not knowing the amount of time until approval. And so I was looking to see how we could keep ourselves working towards the Go North program, even if this one is not quite ready. So with that, I'm not sure how it would be a monopoly with that. I didn't know if you have another question with that as well.
No.
Okay. Thank you. Thank you. Representative Schmidt.
Thank you, Madam Chair. So first, we heard a lot of facts from Mr. Bartlett. Do we have all of that in writing because some things went by, but I didn't get any of that in writing. Do we have all of that in writing?
We can ask for some, let's, if you can keep your questions focused to those who are in front of us, we can do the committee discussion and reaching out to people. But right now we have.
Well, that's what I want to know. But if that has to be delayed, in my case, that's okay. But we heard that this whole process started in 2024, correct?
The Rural Health Transformation Plan started, it was part of what the One Big Beautiful Bill, HR1, that was enacted in July of 2025. The opportunity to apply for the Rural Health Transformation Grant was September of 2025. I think the PA Compact work had started in 2024.
Okay, and then we heard that if the state says they get in early, they get more of an opportunity to participate in the formation of all the aspects of the thing. Is it?
Yeah, I would defer those questions to both the PA Compact folks, the folks that are working on that, as well as OPLC. We're really here speaking from the department and Go North perspective on how this would improve workforce access.
Follow up?
Only if it's actually directed to the department or the governor's office. If it's for somebody else, please hold the question.
Well, I don't know who it's for, and let me ask the question. So the question is, are we already involved with this formation process so that we're early participants in getting a handle on what it's going to be?
I can answer that question. No, we missed the initial formation and they do not yet have the rules in place. So we would be a late joiner on that.
Okay, so then, but it's not going to be fully ready until 2027, is that correct?
So what we are suggesting right now, so there are a number of states who have already joined or begun the Interstate Compact for physicians' assistants. We are here from the department and Go North suggesting that this policy aligns with both federal priorities as well as the governor's priorities, as well as the experience within the department in thinking about workforce and workforce retention in those communities. So I apologize, Representative. I would want to defer any of the technicalities of the compact itself to either the folks that are representing that compact or OPLC.
Okay, thank you.
Thank you. I don't see any other questions for you. Thank you very much. Next, I will call up Executive Director Dee Juris. I believe we have a few questions for you.
Good afternoon. I'll believe the few questions when I see it. Happy to be here to take questions. For the record, Dee Juris, Executive Director, OPLC. If I might just take a brief minute to step back, I can kind of do a big picture, address some of the questions that I've heard, and then see what I missed.
That would be very helpful.
Okay, great. So I wanted to just describe the primary difference in the public policy decision, the implementation of a reciprocity or endorsement, those words that we use interchangeably, and a compact privilege. So we have the 31017, which talks about the substantially similar requirements, means that you can, if you have a credential in another state, you can be granted a New Hampshire credential. For physician assistants, I just looked it up. The substantially similar requirements are that every state, with the exception of Arizona, and the District of Columbia is considered substantially similar at this moment. So presently, a PA who is credentialed in any other state or DC except for Arizona can apply for a license in New Hampshire, complete the universal application, say I have an up-to-date license and it's unrestricted, and they will receive a license to practice in New Hampshire. They have to then continue to renew that credential every 2 years because it is a New Hampshire license. If New Hampshire joins a compact, or any state that joins a compact, if they are issued a compact license, they don't need to get a credential from the state. They have a license. It enables them to practice in any participating state. So they don't have to do the continuing ed in multiple states. So say somebody's licensed in Maine and New Hampshire. Currently, a PA would hold a license in both states, would do continuing ed requirements, would update, would pay fees for 2 credentials. If both states were in a compact and the compact was fully functional, they would hold 1 compact license and do the continuing education in their home home state. So that's the primary difference. Another thing I wanted to mention is that New Hampshire's requirements for PAs it doesn't differ with you have to have certain number of hours. That's not spelled out in law or rule. And so the requirements there, I would say, would not differ. Or if there are states that require more, that would be more stringent than our current requirements. I would also note that just because you participate in a compact doesn't mean you have to get a compact license. So somebody can say, nope, I don't want this compact. I don't want the strings. I don't want to have to do with that. I just want a PA license in New Hampshire. I'm going to live here. I'm going to work here. I'm not going anywhere else. I don't want to get in the middle of that. Joining the compact doesn't change anything. New Hampshire is currently participating in law in 8 compacts. I did email the chair a link from the Council on State Government, who maintains a lot of data there, and it has laid out every type of compact that there is and which states participate. So it's a nice grid. You can scroll through it, and she can distribute that to the committee so you can get a broader sense of who's participating. And the 3 years for the rules to get together for a compact is not out of the ordinary. I would say that's fairly standard. So this group, the legislature has had New Hampshire join. I'm trying to pull up a lot of data up here. I was trying to really succinctly get to all your questions. Let's see. So currently, speech, counseling, occupational therapy, are all the state has put in law. We are going to participate, but they're not yet operational. So they're in that process. We are participating in a nursing compact, which is we're participating in. That's fully functional. That's running. The same with physical therapy, psychology, social work compact. We are participating, but that's not yet operational. And then physicians is the last one participating and fully functional. So just so they have a picture of that landscape. Let me just see, I have a lot of windows open. Let me see if there's anything else I wanted to catch before I open it up to whatever you need. The last piece, I think I heard some question about maybe we can find some other way to satisfy the requirement in the grant funding. I don't believe that is the case. It's my understanding that the federal administration said, here's the checkbox, do these things, basically a rubric. If you do these things, you will get more money, you will get a higher score. And this specific compact, because it's federally driven and is kind of a nationwide process, I believe that was specific. So I don't think that this committee would say, well, we're going to do a different policy to help increase access for PAs that would not satisfy the requirements of that grant. That's a little bit over my skis, but I did review the proposal when they were saying which of these are we already participating in for them to note and to do that review. So I wanted to highlight that as well. Just double check if I have anything else, and then I'm happy to open it up. I think that's the last piece from what I was just, you had asked about a felony or misdemeanor conviction. That is definitely in the text to exercise a compact privilege. So this is the individual person must have no felony or misdemeanor conviction, which is different than if you want a single state license, you can have a felony or a misdemeanor depending on the circumstance. There's lots, we don't need to get into it here, but that doesn't preclude you from working in a licensed profession ever, but it would preclude a PA from exercising a compact privilege.
Thank you. And thanks for clarifying that it would not kick out PAs with the record. Yep. So that's helpful. Representative Grota?
So in a typical compact where the rules are set by the compact board and everybody who is part of that compact meets those requirements, in this particular case, the board decided that the PAs will work to the standard of the state in which they are. Who is issuing the license?
It's the home state where the person resides. And I don't think that this compact is different than any others. Okay. If you're practicing in a state, you have to abide by the laws and the regulations of that state when you're there. So if typically New Hampshire actually has a broad scope of practice, I'm sure this committee has heard there are some professions where you can do a lot more in New Hampshire than in other states. So typically we are on it would be more difficult for somebody to leave New Hampshire to go to another state. They would often be limiting their scope of practice. Then to come here, it's often more expansive. So there's that challenge there. But the home state, wherever you are, issues the credential, the compact credential, if they are a participating state.
Representative Slotchie?
Thank you, Madam Chair, and thanks for taking my question. The funding that's associated with taking this action, do I understand that correctly, that it's to be spent getting the program stood up? So covering the costs associated with joining the compact. So what I guess intend is that we can't just go spend this money willy-nilly. The purpose of the funding is to cover the costs associated with the compact. And so the policy decision is, I think, much more stark in that scenario, but do I understand that correctly, I guess is my question?
I just want to make sure I understand. When you say the funding, do you mean the grant funding from the feds? That is not my understanding, and the department can speak to that if I get it wrong. But my understanding is that the funding it's basically like, hey, you're going to do what we want, and we'll give you money to do what you want. And so it's not going to take even $1 million to stand up a compact like that. The fiscal note, I submitted an updated worksheet. I don't see it copied here, but the estimate is the 100 to 500,000, and that's just to do the IT work. And then we did quote the anticipated loss of revenue if every PA who is currently licensed in New Hampshire, but their home state is not New Hampshire, did no longer paid renewal fees because they joined the compact, which is like, that's the most extreme scenario. But that loss of revenue would be $100,000. So the cost to the state is not a $20 million lift to join the compact. It's just the Fed's way of saying, we're going to get you to do what we want, is my understanding. It's some carrot and stick approach. So the funding does not have to go to the PA compact. Did I do well? Yeah. Okay.
Yes, you can follow up.
So it just goes in the general fund? No.
It's attributed to this office, the Go North office, is my understanding, is similar to the governor's office for emergency recovery and relief, right? There were giant federal pots of money that an agency distributed. And so my understanding is this grant is being directed to the governor's office, this kind of side piece of it, the Go North office, and then they're using that for the initiatives. But it's replacing a lot of other existing funding that was much more specific. My understanding is it came with a lot heavier of an administrative burden. This is more, this might be a trigger word, and it won't be, it's more similar to a block grant. You say you're going to do this thing, here's a big chunk of money, go do those initiatives generally in that priority. And it's, am I getting close?
Yeah. So within the state's rural health transformation plan that went to CMS, the state put forth a bunch of proposed uses of funds around increasing access to primary care, increasing access to specialty care in rural areas through telehealth, supporting our safety net hospitals for long-term financial sustainability, looking at different service delivery models, a whole bunch of different things. CMS approved that, and so the use of funds has to tie to those, what CMS approved. So we can't use it for anything and everything. We can use it to support workforce through recruitment intention or retention. So we could provide a grant to a provider to recruit a primary care provider to a rural area, provided that that provider is willing to commit to serving that rural area for 5 years. So there are some bounds around what we can and cannot use. The $20 million that was tied to the policy commitment is not solely dedicated just to implementing and executing the PA compact. It can be used for the rural health transformation program writ large.
That answer, or did you have a follow-up? Okay, thank you. Are there other questions? Representative Schmidt?
Thank you. One of the things that has been mentioned several times is the importance and also how this plan is going to facilitate that to get more PAs out into the rural areas, because we know that they are less adequately serviced than people who, I live in Dover, so I'm right down the road from Portsmouth Regional, is where I also have providers and so forth. So I'm very well taken care of there on the seacoast. Not so good in some other areas that are more rural. Are we getting people to make commitments to come in, to make commitments to go up into the rural areas and get that funding and provide the service to those people? That's what I'm concerned about.
We've just started. I know that there have been, so one of the examples we used in the grant that CMS approved, that was one of the federally qualified health centers up north, had an idea to do a shared staffing arrangement with an urban provider, I think actually located in the Seacoast area, where that provider would split time and go up north to increase access. And so that's a proposed use of funds that we can invest in to facilitate that, not just in with that federally FQHC, but any rural primary care provider that's interested in that type of model, we can support as long as they're in a rural area. And then there are two major workforce initiatives with the community college and UNH, and they'll be actively partnering with rural providers to help increase the pipeline of people who get a credential and a degree working then in a rural facility.
Thank you. Seeing no further questions, thank you very much. And I will close the hearing on Senate Bill 425, and I will open the hearing on Senate Bill 457 and welcome up Senator Reardon. Thank you, Senator. When you're ready, you can introduce yourself and introduce the bill.
Thank you, Madam Chair. My name is Tara Reardon. I'm the senator from District 15, Concord, Bow, and Hopkinton. And I'm here to introduce Senate Bill 457 relative to the licensing of physicians who graduated from medical schools outside of the United States or Canada. That alone is a change from how this bill was introduced. It started out as international physicians. And I am not an expert. There's a lot of people behind me who are, but this bill is constantly morphing. It was brought to address the shortage of physicians by creating an alternative pathway to licensure for qualified, internationally trained physicians to practice in the state of New Hampshire. As this committee is well aware, we're facing a shortage estimated at almost 200,000 people who live in New Hampshire in 26 federally designated primary care professional shortage areas. So this bill is an attempt to bring more primary care professionals to the state. As amended in the Senate when we worked on it, we changed some key eligibility criteria, better recognizing comparable education and training and performance experience outside the United States to what our requirements are here. With that said, since that time, I know the Society for Physicians Associates has some concerns and proposed modifications to that. I brought this bill on behalf of Bi-State Primary Care. They're here. And we are open to some really good suggestions to address the concerns of that folks have about this bill. So this version, definitely not ready for prime time. People behind me who will provide more information.
Thank you very much. Are there questions from the committee?
Thank
Seeing
you,
none,
Madam
thank
Chair.
you very much. Sorry, I'd stuck those ones. I will call up Malcolm Hathaway again, please, to speak on this bill, Senate Bill 457.
Good afternoon once again, and for the record, Malcolm Hathaway again. Thank you for the opportunity to speak here, Madam Chair. You know, I think just we center our concern over safety. The New Hampshire Society of Physician Associates opposes SB 457 in its current form. NISPA shares the desire to attract more physicians and providers, absolutely, to practice in New Hampshire, seeing the need. However, but any such efforts towards that, we feel need to be balanced with safety while we're bolstering care. The Senate-passed version does not do enough, we feel, to ensure public safety. However, NISPA believes that some modifications to this bill can attract more physicians to practice safely without putting the public at risk. This bill would be improved by recruiting requiring international physicians to have their license application examined by the Board of Medicine, and not clerical staff that are non-clinical, such as OPLC. The bill should require applicants pass their boards in the United States, we feel. And also, the bill should specify that applicants must demonstrate they have completed 10,000 postgraduate clinical practice hours. Thank you for receiving my letter to the committee, and I provided some rationale for proposing these bill changes.
Thank you.
And happy to answer any questions.
Thank you. Representative Sitek?
This is a question of the chair. Is there anybody from the New Hampshire Medical Society here?
No, I do not have anyone from the New Hampshire Medical Society.
You're speaking for the New Hampshire Medical Society, not for the physician's assistants. This is about physicians.
I'm here.
Are you staying in your lane, is what I mean?
I'd say that as the physician's assistants, they do have insight as to some of the licensing, and so they can have a concern about who is approving these physicians who they may have supervisory agreements with, or they may be working with. And so the relevance of the certifications of the physicians would be relevant for them.
We work alongside physicians, certainly, and we are a team, and we have a lot of respect for physicians. We would like to see some better safety measures in the bill for the safety of the patients we all take care of together.
Thank you. Are there other questions? Seeing none, thank you very much.
Thank you.
Next, I'll call up Christine Stoddard from the Bi-State Primary Care Association.
Good afternoon. My name is Christine Stoddard from Bi-State Primary Care Association. I am the Senior Director of New Hampshire Public Policy for Bi-State. We represent community health centers across New Hampshire and Vermont. I work in New Hampshire and sometimes at the federal level. I am also the co-founder of the New Hampshire Healthcare Workforce Coalition. We have been a coalition since 2018, and that is where this bill comes from. All of the members of this committee actually have community health centers in your districts. And as has been previously noted, workforce shortages are a big problem for the community health centers across the state. And I do have one story from a community health center FQH or CEO that I'd like to share with you. He was not able to come to the committee hearing today. Ken Gordon is a CEO of Coos County Family Health Services. They have health centers in Colebrook, Berlin, and Gorham, and they also operate domestic violence programs in their service area. Ken had an opening for, I think he said 3 years, don't quote me on that, I know I am, but, and when they were trying to hire someone, they could not find a qualified physician because FQHCs have different rules than private practices. They have to follow the Health Services and Resources Administration rules. It's not just, or they are not just a primary care practice. He couldn't find anyone. And they finally found a podiatrist who was educated and trained in England. This person was forced to go back to school, back to podiatry school, and also retake all of his boards. And had he not had the financial ability to do that, Ken would still not have been able to fill his position. That doctor's unique. He came here for reasons that have nothing to do with this bill, but that's a unique situation. The federally qualified health centers are at a capacity issue where if they can't fill positions, it extends the wait times for all of your constituents. So the Healthcare Workforce Coalition was formed out of similar concerns across the spectrum of care, and the this recommendation, creating a pathway for international physicians, was also included in the Giving Care Plan that was created by the Endowment for Health. And our coalition has slowly been chipping away on the things that were recommended in the Giving Care Plan by the Endowment for Health. And this is one of them. And I am happy to entertain any suggestions that make that are true safety concerns. I did not intend when we were working on this bill to change any of the safety things that would keep patients safe. And if it is worded incorrectly, I'm happy to change it. But I do not want to erect barriers that don't need to be there. The way that this is drafted now, it treats the board requirements are the same for internationally trained physicians and physicians trained in Canada and the United States. And the bill also requires that someone pass a TOEFL, which is an English proficiency exam. If there are other concerns outside of those, we're happy to work with any professional association to minimize those concerns. I'm happy to answer any questions.
Thank you. My first question is, I'm not sure if you're aware that English is sort of the official language of medicine, where if you go to any major medical meeting, regardless of where in the world it is, their discussions on the research will be conducted in English.
Yes,
And
ma'am.
I'm curious why you would believe that just basic fluency in English language is adequate to discuss potentially complex health conditions with patients.
So I'm not wed to that idea. If there is a better suggestion, very open to it. We looked at what other states have done. So there's, I believe, 24 states that have done similar, passed similar legislation or are working on similar legislation. And I'm happy to share that information with you. They're very thick reports, so I didn't want to print them for you. But we're happy to look into that if there's a better way to word it. That language, I believe, came from Wisconsin.
Thank you. Are there other questions, Representative Sitek?
Ms. Stoddard, this may not be directed to you.
Sure.
I see other pink cards, but a quick glance at the physician's assistant letter raises what look like reasonable health, public health and safety concerns. I don't know. I would like to hear. You've talked about
Sure.
convenience. I'd like to focus on their
Yes.
issue. It may not be for you, but I'd like to hear somebody speak to their concerns.
Yes, I did ask in a phone call earlier today where the hours requirement came from, because actually the physician statutes in New Hampshire are pretty bare bones, coming from someone who's written a lot of statutes. They're very bare bones. What the law is actually, a lot of it is in rule. And so if you are looking at the statutes and not looking at the rule, you wouldn't see that the years requirement, the 10-year requirement or 5-year requirement is actually in the Board of Medicine rules. So we used the 5 years because I was trying to be consistent. But if it's 10,000 hours of training is the equivalent of 5 years, then that's fine. I don't have any issues with that.
Thank you. Are there other questions? Seeing none, thank you very much. Next, I'll call up Ben Bradley from the New Hampshire Hospital Association.
Good afternoon, members of the committee. My name is Ben Bradley. I work for the New Hampshire Hospital Association and represent all the hospitals in New Hampshire. I don't have written testimony, but did want to provide some perspective here, thanking Senator Reardon for her attention to trying to bring greater competitiveness in New Hampshire to recruiting providers to the state. I do want to point out that New Hampshire already does have a pathway for international physicians to be licensed in the state, and I think DeJuris may be able to provide some perspective on what that looks like. And we generally support the principle that we want to make New Hampshire more competitive in recruiting qualified physicians and not less. So if you are going to move forward with this bill, to contemplate if there are any additional requirements that they be geared towards patient safety that may not otherwise already be addressed in the current process for international physicians. we do have, I just want to cite specific parts of the bill real quick for a couple of questions for you to contemplate. The first is on page 2, line 24. It reads that the applicant has completed a residency, at least 2 years of postgraduate training or substantially similar postgraduate medical training, which is accredited by the equivalent of the ACGME in the individual's licensing country. Now, for physicians who have graduated from medical school in the United States or Canada, that substantially similar equivalent has to be determined by the Board of Medicine. This provision here doesn't acknowledge that the equivalency would be determined by the Board of Medicine. That may be an area you'd need to amend. The second point, the second question is actually the same section, page 2, number 8. So that is on line 29 of page 2. It says that the applicant has an offer for employment as a physician at a healthcare provider that operates in this state. I don't know of an employer that's going to offer employment to a applicant that doesn't already have or hasn't somehow or working towards securing the license that they're going to be practicing in as their employer, so as their employee. So just, it seemed a little bit backwards to suggest that the licensee needed an offer of employment before they had the license secured. I'm happy to take any questions from the committee.
Thank you. Are there questions from the committee? Representative Sitek?
You didn't indicate whether the hospital association is for or against the bill.
So I didn't because I wanted to express that we are generally very supportive of trying to make New Hampshire competitive in recruiting qualified physicians. And so I think that's what this bill attempts to do. The language of the bill, I think, as the sponsor pointed out, is not ready for prime time. And so I didn't want to indicate that I supported the bill or the Hospital Association supported the bill under some false expectation that it was, ready to go. So forgive me for that gray area, but I just didn't want to commit one way or another.
Thank you. Are there further questions from the committee? Seeing none, thank you
Thank
very
you.
much. And next I'll call back up Executive Director DeJuris to speak.
Thank you very much, and thanks for your patience on what I know is a long hearing day. Just for the record, Dee Juris, Executive Director at OPLC. I just wanted to briefly highlight the Hospital Association did mention there is a current pathway for physicians who are educated outside of the U.S. and Canada. And that is contained in the Board of Medicine rule. If you'd like the citation to look it up afterwards, it's 302.01. And it provides, it kind of gets down more and more specific. So it'll be like, all right, if you're in a school in the U.S. and Canada, it's got to be accredited by this group, you're good to go. If you're at a medical school outside of the U.S. and Canada and you have a standard that's recognized by these national associations, good to go. If you don't have any of those, you have 2 years of postgraduate medical training, year 1 and year 2, in a program accredited by these other accrediting bodies. And at a minimum, it needs to have a board certification or 10 or more years of practice combined with the 2 years of postgraduate training. So we're kind of getting, right, if it's not U.S. and Canada and it's not this accreditor and it is this, it's 10 years plus 2 years of postgrad. Or if they have not completed 2 years of postgraduate training in an institution that has those accreditations, there's a petition process to the board to say, here's the reason you should approve me. And then the board does review that specifically, that petition on the merits of that individual applicant. So that process already exists in rule. And is functioning. So to the extent that is to say that we need to open up a pathway for people to come in, the pathway does exist. My understanding of the intent of the bill is to make it easier. Hence, at the initial proposal, and I believe in this one as well, it said 5 years instead of 10 years. So that's a policy decision that this body may choose to make. But I would just like to note, so from the version as amended that is before you, here's the changes from the current process, and it's just 4 things. So the first one is reduce the number of years in practice from 10 to 5. But then it actually adds 3 criteria that don't currently exist. So the first one is require that the years of practice all be in the jurisdiction where the physician is presently licensed. And no such requirement exists now. So that would mean you couldn't have 5 years if you were in a different place than where you were credentialed. So that could create some issues if somebody's moving, if they're mobile. I can think of a lot of scenarios. So that doesn't exist right now. It's just 10 years. And it's not in that specific place where they're presently licensed. The next is that this would require that they have an offer of employment in New Hampshire. No such requirement exists now. I think that's more of an immigration thing. There's some challenges with getting work visas if you don't have employment lined up, but that's not a licensure issue. So I would hesitate to put it in licensure requirements. And then the fourth one is to require that they take an English language proficiency exam, and no such requirement exists at this time. If the policy change were to be made, the office already does have a contract for an exam, so there are some instances where they could require that, but we already have a standard process. So if you wanted to move forward with that and make that additional requirement, I would respectfully request to work with you to make it fit within the existing process, but there is not currently that requirement now. So this bill as proposed would reduce it from 10 to 5, but add 3 barriers.
Thank you. That is helpful. I would be interested in knowing how, what the current process is to make sure that somebody's English skills are adequate to communicate these important topics with their patients.
And we can get back to you on that.
Thank you. Are there other questions from the committee? Representative Schmidt?
Thank you, Madam Chair. Well, I recall an instance about 60 years ago when I was living in the Midwest, and I had a doctor that came to the school that I was teaching at, and he happened to be from Poland. There's no disparagement in the Polish people, but he was a practicing doctor, but his English, although he may have been very proficient in English, his accent was so thick that he was virtually impossible to understand for me, and I I'm a native speaker of English, so I was not struggling with my language. I was struggling with understanding him, and he was taking lessons from me at that point to help him with his accent, because, as I say, he was virtually incomprehensible when he spoke English, even though he may have been able to read and write it very well. So is there some, there's a reference always to English proficiency in here. Do we factor that into consideration in our evaluation with your OPLC organization?
Yep. So I think speaking to that, we'll give a touch on a bit of the Representative Leon's question as well, the chair. So currently, the assumption is that your English proficiency is demonstrated by passing these exams that are in English and are medical terms. So there was concern about just the basic English fluency. This is, if you can pass a medical exam, then that demonstrates your proficiency. So that is the current standard. I guess what I would posit is, if you do not have any concerns right now with what's happening, if you're not alarmed with safety issues or oversight, then there is a current process. So that might weigh into your consideration.
Thank you, Madam Chair. I'm going to roll back a second to something you just said and help me out with this. You said that they cannot use work in an area where they're not credentialed, right? As far as the time?
So the way the bill is drafted presently before you, I just want to be careful about the wording. It requires that the years of practice be in the jurisdiction where the physician is presently licensed. So if they're holding a credential within a jurisdiction, the years of practice have to be within that licensing jurisdiction. So theoretically, you could be licensed in a country and working in a different country. That would not currently meet the way the bill is drafted.
So if you're working in a country where you're not credentialed, are you working without a license?
I don't know the internet. I don't know international, right? So I couldn't posit that. I guess I'm just saying that you can imagine a situation where, okay, somebody's licensed for 1 year in this country and then they move to another country and get a license, but they would have to work 5 full years in that current credentialed country, so that you wouldn't be able to rely on it. So I wouldn't want to get into hypotheticals about unlicensed practice. I would just say I can imagine a world in which you don't live in the same place for 5 years.
So I'll ask just
Like
one
the
question
EU.
on this that's relative to that. If somebody was a doctor, had been practicing in Iran for a long time, but they are now seeking asylum somewhere because they had spoken out against the government or something else, they're not necessarily practicing there because they are getting asylum in another country, but they want to come and take their medical experience for maybe 15 or 20 years or 40 years working as a doctor in Iran or somewhere else. The language that's in the bill in front of us would prohibit that, but the existing process would potentially have a pathway. Because if they're having asylum somewhere, they're not practicing, they couldn't do that under the new language of the bill.
Yeah, I'm trying to. There's obviously a lot of hypotheticals there, but I think generally the answer is yes, that there would be a pathway for that person. Yes,
Today.
currently. Yep.
Thank you. Representative Groda?
So I have a question about availability and accessibility because this is being promoted as a bill that gives greater abilities for people. And the same argument was given last year, and with the expansion of the PAs. So, since we've passed that legislation, have we seen an influx of physician assistants to New Hampshire?
I don't think I'm prepared to answer that right now.
Okay.
I don't know. I couldn't say even yes or no.
Okay, thank you.
Are there other questions from the committee? Seeing none, thank you very much.
Thank you.
Is there anybody else here to speak on this bill? Seeing none, I will close the hearing. I think this has been a good and productive day. I am planning to schedule us for work sessions on a number of our bills next week so that we can work through the 3 early bills and the other ones that we're looking to really sink our teeth into. We will notice to be able to do executive sessions on those that we're prepared to do so, but I'll be coordinating with the ranking member about what we're going to do. And then we'll follow up with the hearings on our remaining bills that need to be heard on likely on the 15th. So thank you all for all of your hard work. If you owe me a report, please get that to me because even though having bills on the consent calendar may not meet that threshold for us having session on the 9th, I want to make sure that we are doing our part to make sure that we don't end up with another backlog. And so if you owe the report, please get that to me. And thank you all. We are adjourned.